Good morning to all of you here in person. Good morning to, let's see, better part of 50 folks attending on Zoom and climbing by the moment. My name is Pat Wildes. I'm the director of the Government Law Center here at Albany Law School. It's my great and sincere pleasure to welcome all of you to the law school for this really fantastic collaboration between our Government Law Center and the Albany Government Law Review. This is the second year in a row we've done a really great collaboration on Symposium, and just based on the planning and how wonderful of a job our students have done, I think we'll keep doing it in the future as well. Today's program is titled Transforming Futures, Education, Law, and Youth Wellbeing, and we're grateful to convene this really important set of discussions. Before I get into that, though, this is a really important year for Albany Law School. 2026 marks 175 years for Albany Law School. For those who are not historians and are not huge fans of the law school, have never been here before, that makes us the oldest independent law school in the country, which is really great. And we're doing a lot of great things this year to kind of commemorate our standing in that regard. It's especially fitting that during this banner year that we continue to gather to talk about topics in government and law and the kind of intersection between them, considering where the school is located here in the state's capital city. We're also proud that Albany Law just last summer was ranked the #1 government law school in the country by Pre-Law magazine. That is not the first time we've received that designation, and certainly hope it won't be the last time either. And so many of you, our alums and those who are engaged with us, are a big part of why that happens. Speaking of developing lawyers and leaders, just a few weeks ago, our own Government Law Center just doubled the number of fellows we have in our program. Historically, we had around 30, and now we have over 65. There's an extraordinary amount of excitement and optimism that our team takes from that. Over half of our graduates from Albany Law School end up going into careers in public service. It's one of the highest rates in the country. But seeing so many students investing in their future, wanting to go into public service when there's a lot of other lucrative opportunities out there, is something that really inspires us every day. And it's a huge breath of fresh air for us. So it's in a similar vein that we're really excited about today, where we talk about a different next generation, which is our children. And today's children, as so many of you know, because if you're interested in being here and our expert panelists who focus on this every day, our K through 12 education system, the kids in that system right now, they're our present and our future, right? And we need to focus on their well-being today, not just a couple years down the road. So we're thrilled to be bringing together leading scholars, practitioners, policymakers, and students to bridge theory and practice in a way that's, can strengthen all these discussions. We're hoping that discussions like the one today aren't just analyzing current and pressing issues, but they're actually kind of informing future and hatching future ideas and initiatives that can really impact the lived experience of young people and their families, both in classrooms and in their communities. Just a brief moment about what this morning's program is part of. This is part of our Warren M. Anderson legislative series. So that's a 4-part legislative series we do here at the Government Law Center every spring, focused on pressing issues facing state and local government. This year, the programs are, of course, on K through 12 education. This morning, we've got 3 other programs on transportation, on healthcare, and on childcare in the coming weeks, and we're promoting that separately outside. I can't start today's program without acknowledging our really generous gift that makes programs like the one today possible. That's a gift made in the memory of Sharon P. O'Connor, class of 1979. So we really appreciate the gift in her honor year after year to make sure programs like this happen. And just finally, a quick note before I hand the program over. I want to extend so many sincere thanks and appreciation to all those who've made today possible. My part of this is easy. I get to show up and speak to you all and get to talk to everyone. The hardest part is the people who aren't going to be talking as much today. So thank you to Chell Miller. Thank you to who's our program director at the Government Law Center, to Jessie, Sullivan, who's done a fantastic job of pulling this whole event together, the whole day together through the Albany Government Law Review, and all those from both of our teams who've made this possible. Of course, thank you to all of our distinguished panelists and speakers today. And now the part that you've all been waiting for, the logistics that I will share with you, so that if you want CLE credit, please listen closely. If you don't, then you have another minute. If you're pursuing CLE credit today as an attorney and you're here in person, you're going to want to make sure you hand in the forms out in the hallway to Lisa Rivage. I will hear about it if you do not hand them in on time, so please, at least for my benefit, hand them in on time. We want to get you that credit quickly. If you're attending virtually, please turn your forms in within 24 hours. About halfway through the program, our moderator is going to pause and read the CLE code. If you're in person, you do not need the CLE code. If you are online, you do need the CLE code. And then just finally, following this morning's panel, we have a really fantastic lunchtime keynote address. Of course, this whole day is free, and we're really happy to offer this all free. Lunch is free, wonderful keynote address down in the gym, which is 2 stories below us, by the Commissioner of the State Office of Mental Health, Dr. Anne Marie Sullivan. And we hope you'll enjoy today. So I'm going to hand it over to Konrad, the Editor-in-Chief of our Government Law Review, and we're going to be on target here for starting right around 10:15. So thanks for coming.
Thank you, Pat. Good morning, everyone. Thank you all for coming. My name is Konrad Dalland. I'm the Editor-in-Chief of our Government Law Review. It's my privilege and great pleasure to welcome you all here today to Government Law Review's 19th Annual Symposium. The Government Law Review's core mission is to provide a platform for the discussion of pressing issues in governance and public policy. The symposia we have hosted over the last 19 years have advanced that mission and put a face to the scholarship that we publish. Today's symposium will be no different. I have a couple thanks to say before we get started. First, I'd like to thank Pat Wildes, Chell Miller, and the entire Government Law Center for all their assistance and support in making today possible. I would also like to thank all of our amazing speakers and panelists and moderators who made the trip to join us all here today and will be leading us through this important conversation concerning K through 12 education. Finally, I'd like to thank Jessie Sullivan, our Government Law Review's Managing Editor for Business and Production, for her dedication to the symposium. This has been a year-long effort that would not have been possible without her. Before I hand things over to Jessie, I just want to say once more on behalf of Government Law Review, welcome and thank you for coming.
Hi, everyone. My name's Jessie Sullivan. I'm the Managing Editor of Business and Production for the Government Law Review. First, I'd like to echo Konrad's thank yous. Thank you, Pat and Chell from the Government Law Center, for all of your guidance and your expertise. I really couldn't have done this without their help along the way. And I would also like to thank Konrad, our Editor-in-Chief, for all of your support and the trust that you had in me to put all this together. And to our wonderful panelists that we have here with us today, thank you for taking time out of your busy lives to be here. I've had the distinct pleasure of putting together this program and bringing together experts in each of their respective fields to discuss what the current state of education is and what we can do to improve the system. To start this morning, we will talk about the biggest issues facing education in New York, including the allocation of school funding, the impact of the federal administration's focus on immigration enforcement, and current state legislative efforts. We will then hear from the Commissioner of Mental Health, Dr. Anne Marie Sullivan, for a keynote address over lunch on the mental health needs of children and teens in New York State. After which, we will turn the discussion to special education and how we can best support students with disabilities, where we will discuss the impact of exclusionary discipline on special education students, as well as barriers to access for the children of non-citizens. We will then finish the day with a discussion on equity in education, where we will address policies that limit educational access and produce inequalities, discipline in schools, educational equity for court-involved students, and equity in Indigenous education. And with that, I just wanted to thank you all for being here today. We couldn't have had a symposium without your attendance, and we hope you enjoy today's program. Now I'll invite our moderator for this morning, Kyle Belokopitsky, the Executive Director of the New York State Congress of Parents and Teachers. Thank you.
Hey, thanks for having us all. And let's give Jessie and Konrad another round of applause. I was a student here a long time ago on a journal, and I couldn't imagine putting this together and also doing all your work. All of our panelists, let's turn our mics on because we're just going to be very conversational. Everybody's bios is fully in your program, so we're going to save that. We're going to do very quick introduction, starting with my dear friend Cindy. Cindy, and you can do a quick intro, Cindy.
Good morning. It's a good thing we're good friends because that was a complete throw in there on that one. Dr. Cindy Gallagher, I am the Director of Government Relations for the School Administrators Association. That's basically an organization of that middle tier of educators, not superintendents, not teachers, but principals, assistant principals. Prior to that, I was with the State Education Department. Prior to that, a speech pathologist in one of the local schools around here.
Thank you, Cindy. Jeff.
Hi there, Jeff Matteson, Senior Deputy Commissioner for Education Policy of the New York State Education Department. Prior, I've been a teacher, assistant principal, middle school principal, high school principal, superintendent of schools, and a district superintendent of a BOCES. My dad always said I'm the one son who couldn't hold on to a job, but I'm here in this one and looking forward to speaking with you today.
Thanks, Jeff. Shanell.
Good morning, everyone. My name is Shanell Brown. I am currently an assistant principal with at Albany High School, City School District of Albany. I have previously held positions as a secretary at the middle school that I attended as a child, moving on to being a behavior specialist, school counselor, and now an assistant principal.
Thanks,
Thank
Shanell.
you.
Brian?
Good morning, Brian Cheknicki. I'm the Executive Director of the Association of School Business Officials. These folks are the Assistant Superintendents for Business, Finance, what have you, the CFOs of school districts. Previously spent 18 years with the state at the Division of the Budget, the Governor's Office, and the State Education Department.
Thank you, Brian. Bob?
Yes, good morning. My name is Bob Riley. I'm the General Counsel for New York State United Teachers, and I'm a proud Albany Law School alum. I wasn't here 175 years ago, but
Feels like it,
feels
Bob.
that
Feels
way.
like it. Bob and I used to work together. It feels like it, Bob.
So looking forward to the rest of the panel.
Thanks. And I'm Kyle Belokopitsky. I'm the Executive Director of the State PTA. Previously, I represented our School Superintendents Association. I worked with Bob at NYSET. I worked for the Assembly, Senate, and a governor. So I'm really glad to be here with you all. We're going to jump right in and talk a little bit about school funding. First, I have two comments. I want to give Jeff Matteson congratulations, who just announced his impending retirement. So congratulations, Jeff, for a very wonderful career in education. I know we are going to dearly miss him in New York. So I'm very sad to see you go. You have made such a difference for the children and students and families and educators in New York State. And congratulations, Jeff. On behalf of Shelley Mayer, unfortunately, she could not join us. She called last evening. She is now briefing the Senate on the education budget as we speak at 10 a.m. So she sends all of her regards and her sorries for not being here this morning. So she wanted me to make sure to say she wishes she was here. She is doing very important work right now, making sure that students receive the support that they need through the budget process. So let's talk about that budget process. We are in the middle of budget. Brian, Jeff, I'm going to toss these to you. Cindy, I'm hoping you'll jump in. School funding. Let's generally talk about how schools are funded. It's not just tax dollars. And we talk about tax cap. It's not just, people paying taxes. A lot of school funding and a lot of the way schools get their funds comes from the state budget. Brian, talk a little bit about that. And Jeff, I want you to jump into on what SED's role is in that process.
Sure. So as Kyle was saying, in New York State, funding for schools is a partnership between the state and local governments, school districts, that is. Ultimately, no matter what your district demographics are, you're going to receive some amount of state aid, and you're going to have to put up some amount of local revenue through property taxes. Statewide, if you not looking at the most recent data because that's sort of distorted by some of the COVID money, but generally statewide, it's about 55% of education funding is coming from the property tax levy across the state. About 40% is coming from state aid formulas, and the remaining 5% is from federal funds. But when you drill down and look at individual districts, that picture is very different, and that is a result of how the formulas are constructed. Generally, the formulas are implemented in a way that make sure districts with less fiscal capacity, that is, they have less property wealth, there's less income wealth in their area, they have higher student needs, higher costs. Those districts tend to get more money under the various formulas than districts that are in the opposite situation. So even though you have 55% of education is funded locally statewide, some districts that number is closer to 90%, other districts that's closer to 5%. So you do have a wide variety there. Looking at sort of the legal framework of it, there are a number of different formulas, and they're sort of sprinkled all throughout education law. Education law section 3602 is where the bulk of the funding lives. The foundation aid formula, which funds about 67% of the aid is in that section, but there's also formulas in the 750s. BOCES aid is in section 1950. Education 3641 is a bunch of grant programs. And I mention all this because I've been doing this for 20 years, and even in the last 2 weeks, I found out something that has been in law for 20 years that I didn't know about. So because it is sort of all over the place, it is a lot to track, but they are all built in a way that is trying to address different needs. Foundation aid is sort of a general operating formula that's given for exactly that, just sort of general operating purposes. But then there's some of these other formulas are for targeted purposes like school construction costs, transportation costs, special education, and so on.
And I think foundation aid is what we talk about most in schools and school funding. We had a court case, Jeff, and I want to talk a little bit about that and what sound basic education is and how foundation aid rolls into that and what the department's role is in overseeing really school aid. Jeff?
Right, so we have a department that Brian used to be in charge of, that does all the technical assistance and calculation on the school aid formulas, et cetera. In fact, whenever they're putting this information together, they will have our people model it and send them what the different levers they're pulling will result in as far as these districts, those districts, this kind of student, that kind of student. And we also are responsible for collecting the data from the school districts, and then we send the data over to the Division of Budget so they can do their work. And we'll send a preliminary November 15th, and that's when the original executive budget comes out based on that data. Then they update the data based on February 15th database. And that can have some big changes depending on the school district on what kind of aid is coming. So it's a challenge for school districts to put together budgets every year, not just, a tough money year, because it's a moving target. The money is, it truly is, from the November number to the January number from the executive budget to the February update to what the final budget number is. And when the final budget is adopted April 1st under the laws it's supposed to be, there's time to make an adjustment before budget votes the third Tuesday in May. However, when the budget is late, they have to go with like that original number in January and make adjustments as they come, and they try to budget as conservatively as they can. With the foundation aid formula, when we see certain things interacting in that formula, we will give feedback to the Division of Budget, but also to our Board of Regents. And annually, we will make a proposal for some changes to that formula based on what we're seeing and where we think money can be driven to certain kind of student populations to make sure that they're getting a sound basic education as any other student in the state. So that's why there's these moving parts that some are related to just the way the population is moving, not necessarily growing. So you may have lost population in your school district, but that doesn't mean it's less expensive to educate the children in your buildings because of the students that have moved in, or the students that remain are much more expensive kind of students. And that's the kind of data we run, that we send over there, and we make proposals based on. For example, this year we had a proposal on homeless students, given a special little bump if you have certain homeless students in your school districts, because one of the concerns we had is, even though there's homeless students in every county in the state, and we have that data and we can see where it's growing, where there's more, where there's fewer, we also think there's some underreporting in some areas because the McKinney-Vento law is poorly funded by the federal government. And a local school district will take care of their own. They still take care of the students, but they'll be locally funded to take care of the students. Where if we drove a little aid there, they may more likely bring that out of the shadows and actually deal with the problem. And you can get more community partners involved in supporting that student rather than just the burden falling on the school district.
And Jeff, what happens in October, November when SED kind of works with the Board of Regents to set your priorities? How do you come up with that number? How do you come up with that foundation aid number saying, this is the number we think the executive should use?
So starting at the end of August, beginning of September, we have two co-chairs, they're Board of Regents members selected by the board to work on a state aid proposal. And staff works with them on the proposal, shows them a lot of data. Then they go out and they talk to just about every stakeholder imaginable.
Raise your hand if you talk to them.
Yeah, if you talk to them, they came and spoke to you, got your feedback on the things you're seeing, the movement of student populations, the need of student populations, the things you're seeing manifesting in students' lives that may make it more difficult to have them educated, and what we can do about it. They will then take all of that data together, find the common themes, have internal discussions, start making proposals as a committee, as a state aid committee. That will result in a proposal that tries to bring all of that intelligence gathering into a number or a set of numbers or a base number plus additional proposals like increasing fund for English language learners, or increasing funding for homeless students, et cetera. And it'll be settled and adopted in December.
And so let's talk about where we are in the budget process, Cindy, and chime in here. What's happening now? Where are we going to go? I'm going to go to Bob and Brian next on what is in that state budget.
So before I get into that piece of your question, you've heard, and I was very lucky when I worked at the department that I was working on the first state aid formula. I think it was in 2007. And many of my colleagues will underscore how important that was as a piece of education policy to actually try to establish a formula that could be consistent, that districts could, hopefully look at a year in advance and say, this is where we might be. Currently, to get to Kyle's point, from a school perspective, at least with the colleagues I work with in the schools, the formula is not right-sized at this point for the work that's being done by our colleagues in schools. It is a very different system than it would have been when the formulas were created. So what you're seeing at this point in the process is many of us trying to rethink or call for studies to relook at that formula, to right-size it to the kind of work and the kind of student population and the kinds of needs that we have within our districts to really work on that. So what's happening, at least in part of the work right now with the legislature and the budget, because this is budget season, so we're all responding to one House bills or 30-day amendments or what we're hearing from our field, is certainly we are looking at different pieces. One of the pieces we're really interested in is the UPK childcare and the intersection of those two with the early childhood programs. We're looking at a real need in the formula because one of the key pieces is student enrollment, upon which many of the formulas are based. And certainly student enrollment has been a difficult area in terms of decreasing enrollment for many of our school districts. So it's a busy year. And to that point, we anticipated that this year would be critically important. And I know all of us at this table recognized that early in the summer. And I know that we have definitely escalated all of our work to make sure that we get this year right, because I truly believe that it is a real foundation for the next couple of years that are ahead of us. So.
And I agree, Cindy. I think something that we all work together, it's something called the Educational Conference Board. So the Educational Conference Board is the 7 large education associations in New York State, of which New York State PTA is vice chair along with school boards. Brian Asbo is a part of the Educational Conference Board. Cindy Sainies is, NICET is, Bob's organization. I am PTA. Then we have the Conference of Big Fives. We have the School Superintendents Association, NISCUS, and we have the School Boards Association. And is that 7? Did I count us all? I think I counted us all. And so we meet at this point, I think we probably talk every day via email or text. We have constant conversations because as an education community, we realize we have to come together and work together and put forward a plan together to really lobby the legislature and the governor's office on what is best for children in schools. And so we call ourselves the ECB Educational Conference Board. And we have that school aid proposal that our finance experts put out to the legislature, just like SED puts out their school aid proposal. It's often very aligned, Jeff. I think ECB's proposal and SED's proposal very aligned in our numbers and what we want to accomplish this year. Brian, Bob, Cindy, let's talk actually about the budget, the executive budget. Governor Hochul introduced her budget mid-January. It was a reasonably good budget from a starting point. I think we all agree with that. But now it's our job as advocates to move forward and kind of change that budget in the positive. Bob, what does that look like from NICET's perspective?
Oh, sure. And I'm, I'm not the money guy, I'm the lawyer, but just to give a very, very oversimplified explanation, the governor has proposed a 1% minimum increase for school districts. Some districts will get more. And financial aid formula is a formula, so it has different variables in it. So the governor has proposed changing some of those variables. We have a slightly different idea. We would like to see a minimum 2% increase for the school districts. And we would also want to change the formulas, the factors in the formula to make them a little more relevant, a little more up to date, give a little more weight to what's called English, yeah, I can't speak
English language.
English
learners,
language
ELS.
learners.
Yes.
Give more weight to that. Update what's something called the regional index. As Brian was saying, there's differences based on your region. So we would want to change the regional index, and we'd want to see more aid given to special services like career and tech ed.
Of course.
So that would be our ask for the foundation aid. I don't know if you want me to just add one thing since we're talking about funding.
Sure.
The notion of community schools. Community schools, very briefly, are community hubs. They provide mental health services, supports for people with disabilities and English language learning disabilities. Right now, it's funded by what's called a set aside of foundation aid. It's existing foundation aid. It's not additional money. It's just foundation aid that's segregated for it. We would like to see a categorical amount for community schools of $100 million.
I think we all agree, all of ECB is at that $100 million number for community schools. It's a really proven winner for student success. Shanell, I know Albany has a community school model as well for many of their elementary, middle, and high schools. I see you're shaking your head. So, what does that look like in Albany in that community schools?
Yes, we do. And we actually have someone in the audience who has just moved on from being the principal from one of the community schools that we have in our district. And what that looks like is really looking at not just the child, but the child themselves, but looking at the entire family and making sure that the family has everything that they need in order for not only the child to be successful, but for the family to be successful. And if that means that a child can bring their clothes to school and have them washed there at school, we make that happen. The backpack program also exists where we are able to send food home with our students on the weekend and for those long vacations that we have as well. And it also just means having those professionals that are in the building to be able to help students with any mental health issues that they may be dealing with to get them through the day as well.
I think that's fantastic. And I think one of the things that we know as community schools are that proven model of success for students. And let's talk about that. So Brian, why is 1% not enough?
So you've heard about this, 1% in some districts get it and some districts get into other amounts. And Cindy talked a little bit about enrollment declines. The way the formula works is it comes up with a dollar value that the formula assumes is necessary for each child and then multiplies that by the number of children. And so in districts where we're seeing declining enrollment, no matter what sort of that dollar value is, if you're losing kids, the formula is giving you less money under the idea that you need less because you have fewer kids. But as Jeff was alluding to, there's a lot of fixed costs associated with this. And I use the example a lot. Assume you have a district that's 130 students. And that's not uncommon in New York State. There are more than a handful that are that small. On paper, that district could lose 10% of its enrollment, and which can have devastating consequences on the formula side. However, when we think about a district of 130 students, 10% is 13 kids. And if that is 13 kids spread out, one kid per grade, you've lost 10% of your enrollment, but literally nothing else has changed. There's not a single teacher you could lay off. There's not a single building you could close, right? There's no change in costs. And so there's a bit of a disconnect between what the formula assumes is required to spend on education versus what the reality is. In addition to that, the formula uses this calculation that looks at what does it cost to implement successful school strategies in the real world. And the method for coming up with that number has been frozen since 2015. And so instead of updating that for actual costs, the formula is just updating it for consumer price index adjustment over this time. And we've put this in our association testimony to the legislature about the budget. The gap between what that CPI metric is, even though we know that inflation has been high, but the actual CPI metric is much less than what the actual costs are. And it's I might get the exact number wrong, but over a 7-year span, the CPI index went up by about 17%, while the per pupil spending statewide actually went up by about 36%. And so that gap over time, the formula isn't really catching up and recognizing. And so more and more districts are sort of falling into this bucket where the formula looks at you and says, you have fewer kids, you don't need, things are not costing as much, you don't need money. So you're sort of at this level of funding, you're just going to get an extra 1%, 2%, whatever is decided that year. But the reality is the actual costs on the ground have been increasing much more significantly than what the formula is assuming.
Cindy, you have thoughts on this?
Yeah, I'd like to dig in just for a couple of seconds more about the enrollment. And I think at the end of our conversation today, I think perhaps one common strand will be how complex all of these issues are in education. There was a time where you could have talked about a bucket of state money or a bucket of federal money, or you could talk about any issue and it was a thing in of itself. Let me talk a little bit about enrollment. We do a survey of our members every fall, and one of their top priorities of the top three, student enrollment and student absenteeism this year were their highest, what they thought would be their greatest challenge this year. So when you look at a little bit of that, why is that a problem? Well, as you dug into the comments of how they responded to this survey, one of the main reasons is they thought that the competition that public schools were getting from any number of places was a critical to, the continuing decrease of student enrollment. And so what do you do with that? So, that gets us into a whole other number of topics, vouchers, charter schools, live birth rate declining. How do you deal with all of this that impacts funding so much, but also is critical for program and instructioning? So none of these issues, we'll talk about 1%, but that's really critical. And the factor underneath it, enrollment, touches on so many different efforts that schools are trying to deal with at the same time.
Jeff, thoughts?
Yeah, I mean, just at the 1%, you asked Brian why the 1% is a problem. He gave a great answer, but ultimately what this looks like actually in the field is 69% of all the districts in the state are just going to get 1% because the formula, which is broken now, right? It's not, he articulated beautifully how it hasn't caught up with the reality of what's happening. It means that only 31% of the districts actually care how the formula runs. Everyone else is just going to get, okay, what's the minimum? Because that's what I'm getting is the minimum. That's a broken formula when only 31% actually care what happens in the formula. So all that tinkering we do and all the homework we do, right now this year would only affect a certain percentage. That's why it needs to be updated, and 1% isn't enough, because when you're talking almost 500 school districts getting a 1% increase, and they all have different demographics, they all have different school contracts with all of their labor that has different factors, whatever year it happens to be. They have different levels of reserves, et cetera. And, you can't dip into all those reserves all the time. And what's interesting is districts will get beat up for having reserves. Too many reserves and not spending them down by like the division of budget. You can spend your reserves. You don't need a higher rate increase. And then the controller will go in there and do an audit and then say, you can't use reserves because that's one-time money for long-term expenses in your budget and you're creating a huge deficit. So government sends a mixed message sometimes to our school districts, and that makes the job really difficult for business officials and for superintendents as they try to put a budget together that the community will support.
And it's a great transition into exactly why 1% isn't enough. Let's talk about student need and what our students need, the biggest things we see in our school buildings. And New York is the most wonderfully diverse state in a great country. We have, today 227 languages spoken in our school buildings. We have 8,200 foster care students. We have 183,000 homeless students. Our need is great for our students. 57% of our students would qualify for free reduced price lunch, so they live in some level of poverty. So what do our students, and I want everyone to ask this question. So what do our students need from this budget? What is the biggest things that we can, if we were writing the budget, if we were saying to the legislature, these are the things that we have to add to this budget, what would that be? Cindy?
Hands down, at least from the perspective of the folks that I deal with on a daily basis, school safety and student mental health. So I think Dr. Brown hit on it when she was talking about her program in Albany, the mental health. I'm sorry.
Not a doctor yet.
Sorry,
How
my
about
bad.
She's predicting the future.
I am. I am projecting
for that.
All educators end up, thank you. In terms of student mental
Oh,
health.
it's into your microphone.
Just to reiterate, student mental health and school safety. Certainly, there isn't a problem that isn't a societal problem that doesn't hit the door of a school building every day. And your principal is, of course, the one who is there at the front door every day. So I would definitely say school safety and student mental health.
Thank you, Jeff.
I think simply, while we propose some additional tweaks, as much discretionary money the school district can have to deal with a need is what's important, because you need to allow the locals to address what's in front of them. We might know what they are right now, where we said chronic absenteeism is a really big issue, but it's improved 2 years in a row. We don't know how this year is doing until the end of the year. So if we put all of our money in that one basket, and then we found that what districts have been doing and the levers they're pulling locally is working, then we've missed the boat. So more discretionary money rather than just targeted money.
So more local control, Jeff.
Yeah, more local control through the foundation aid formula. Yeah.
Shanell, what's Albany's need?
I think that the greatest need, and you're probably going to hear it all day today, is that our students' mental health is one of the biggest things that we are dealing with today, and I'm sure many school districts are dealing with today. Our students have a lot of access, more access than a lot of us in this room probably had when we were their age. And they don't have the mental capacity to be able to decipher what's good for them and what's not good for them, especially when there's so many negative things that are being sensationalized out in the world. So I think that mental health is number one, but it's not just the mental health of the student, but it's also for their household, because sometimes it's not just the student that is battling a mental health issue, it's whoever they're living in the household with as well. So when you have that breeding in a household, it really just shows the importance of, community schools and community funding, because that would allow for the wraparound services to be given to families to allow them to be successful all the way around.
Brian.
So I agree 100% with Jeff. Really, that discretionary funding is important. Students have many different rights under both federal and state law to services. And when they show up at a school district store, the district has to provide them, full stop. And the funding formulas don't always fund those opportunities, or they don't fund them in a timely way. And so the more money that the district has available to deal with sort of those, one-off temporary situations, sometimes middle of the year, not temporary, but, family moves in, now the district needs to provide services, right? Having that flexibility is really key. And so that really gets to sort of this, where's the funding formula? Where's the no? If I can just take a very quick diversion, because I also want to piggyback on Jeff's point about absenteeism. We're talking a lot about, what do we want to see changed in the formula, changed in policy to make things better. That's actually a really good example of something the state's done in the past. Pre-2007 and foundation aid, a lot of school funding was based on student attendance. And one of the most important changes that happened with foundation aid was we moved from attendance to enrollment or membership, meaning that no matter what the attendance rate were at the district was still going to get money for those kids. And that's really important, because when we're talking about the chronic absenteeism issues today, we're really focused on the students themselves and what that means. We're not having a conversation about the districts have lost money as a result. And I think that's sort of one of those important changes that, had that not happened, we'd be talking about that instead, that, a district that's at 90% attendance is losing 10% of its funding. The state fixed that, right? These things are possible. And so that's why it's important that we're having these conversations, because we can make things better and really focus on the more important items.
And I think I'm glad you both brought up absenteeism. I know the Assembly just had a hearing on absenteeism. Many of us testified that, and Cindy and I are actually going to co-chair a little committee of ECB on chronic absenteeism, because I know it's been a really important topic of the education community to try to, help school districts and help students be in seats, because we know if they're in seats and they are learning and being involved. Bob, highest need.
Highest need. Well, Jeff and Brian already talked about the discretionary aids. I'm going to come back again. It might sound like a broken record to the community schools and the $100 million of categorical aid. As we heard in Albany, these community school concept addresses the kids' mental health needs, their English language learning needs, and it provides many other services that would help these students succeed. And it may even address, in my view, the absenteeism. If the parents are more involved, they're more likely to have the children, come to school for the services as well as the education.
Agree, Bob. And I think from a PTA's perspective and family's perspective, we would agree probably mental health as well and that local spending. Some statistics I just pulled up from our website. We have a Every Child's mental health page on our website. As FYI, 50% of chronic mental illnesses begin by the age of 14. 50% of lifetime cases of anxiety disorders begin as early as 8 years old. 22% of youth experience serious mental illness each year. And last year, 27% of our students in our school buildings in New York State had a diagnosed mental health condition. Office of Mental Health and OCFS, the Children and Family Services, had a June report last year. And from 2011 to 2021, the rates of youth who were persistently sad or hopeless increased from 21% to 29% for teen boys, from 36% to 57% for teen girls. And this is the most alarming statistic. These are New York State youth. Okay, and those who had reported that they had seriously considered attempting suicide increased from 16% to 22% over the same period. So we know that all of these things, and I think, Jeff, you had said it, school districts know what their students need, and it may be different in each school buildings. I also think we have to destigmatize mental health. I have 2 diagnosed mental health conditions myself, and it's really important that we talk about that. And with our children, my son also has a gross motor tic since kindergarten and a mental health disorder. And when he was, his kindergarten teacher called me, Miss Gina Mahoney, I'll never forget it. And she said, I want you to come into school because you talk about Jackson. And here I think, oh, he's brilliant. He's in kindergarten. They want to talk to me already. And they brought my husband in and there was a school psychologist there and someone from the BOCES was there. We're a small school district, K-8, 300 students. We don't, a very small rural school district. And they said, we think Jackson has a mental health condition and he has a tic. And I cried and I thought I failed as a parent. And I was really supported by the school district and had to realize that it's okay that my son had this gross motor tic. It was just like him breaking an arm. Right? There's nothing wrong with your child having a mental health condition. We have to really destigmatize that from a parent's perspective and from a school perspective. So all important issues. So now we have a couple minutes before we transition to the next topic, which is ironically student well-being. So it's a great transition, but I want to talk about what's happening in DC and funding and how that is going to affect our students and our school buildings and this budget. Jeff, I know. So let's talk about funding first, and then we're going to transition into some other DC kind of policy items. So what's happening with federal funding? How is it affecting New York school districts? I know we disagree sometimes with what's happening with federal funding. So what does that look like from SED's perspective?
Yeah, I think because of the way the states have responded to some of the proposals, I'll just call them proposals, coming from the federal administration, we've beat back the worst challenges of the funding piece. We're recovering from some withholding of certain funds, especially some COVID money that a lot of school districts used for construction type things and all that, and slowly clawing some of that back. Many of our districts lost grants, some mental health grants, believe it or not, were cut by the administration. Some of those are not coming back. But as far as the biggest funding pots with Title I and with IDEA, and even English language learners, even teacher and principal development, some of that money was restored. Is kind of almost miraculous.
We were all thrilled when that happened because we were surprised.
So as far as the funding is concerned, it's level, which is minus 3%, right? Because anytime you go level year to year, inflation takes a toll and you lose some ground, and that's 2 years in a row. So we're behind 6% really. That doesn't have a monstrous effect. School districts make an adjustment, but the funding piece seems to have settled, but it's settled at a 0% increase.
And Brian, Cindy, Bob, is this the federal issues having an impact on local school districts? What does that look like, Brian, and then Cindy, Bob?
I think, similar to the overall funding structure being different by district, who receives federal money is also different. So within a very small number of districts who happen to have very large student populations in the state that are receiving lots of federal money, this is definitely much more of an issue than it is for others. But I think for everybody, it's really just more the uncertainty that it creates. And it's been interesting. I've been involved with our federal advocacy with our national association, and even in recent years, before the current administration, you could see some dynamics playing out where even within the same party, sort of the House Republicans were much more in favor of a lot of these more draconian cuts. The Senate Republicans were less so. And so, I think as long as that dynamic holds here, the uncertainty it creates by having folks that are interested in seeing these cuts and then ultimately not come to fruition does make it difficult for business officials and superintendents to plan ahead, knowing, well, I need to plan next year's programs, but if that money is going to dry up, are we going to be able to fund it ourselves? Probably not, because we don't have enough reserve funds and there's a property tax cap. And so maybe it's not actually hurting their pocketbooks, but that uncertainty really does depress people's ability to move forward.
Yeah, Cindy?
Brian mentioned, I think earlier, that the federal piece of our total education budget is between 5 and 7%. This last summer, we found out just how important that 5 to 7% was for our districts. When there was anticipated cuts to those programs, especially Title I in New York State, we get $1.6 billion in Title I, and we get $1.4 billion in Title II, which are grants to the LEA. In June, when our districts received word that those funds were in jeopardy, one of the school districts closest to Albany that I worked with, literally over the weekend, had to make a decision whether to shut down their summer intervention and remedial programs or go forward. Those are programs that families count on, not only for progressing the students from one year to another, but for a whole host of family reasons. So that sounds like an easy decision, right? Oh, we'll go forward. Everybody's counting on. Well, it isn't, because that means that has to be funded through their own, and that gets the flexibility, that gets to, so we saw critically what that small 5 to 7% meant to our districts. So beyond that, and of course it was restored in July, and we were all very pleased with that. So that's one piece of you asked generally about the federal perspective and how that's impacting our districts. There's the funding, but there's also I think another aspect of programmatically. And if you recall, take us back at the beginning of this school year, there were a lot of executive orders that were certainly causing a great deal of angst in the districts that I worked with. And let me just, I don't know if you want to get into that right now or you want to continue it down, but there was one policy in particular that a shout out to Daniel Bentley Morton, who is a senior attorney at State Ed, came on a webinar with our members to kind of sort out just the impact of the executive orders. One of the ones that has had the most impact was certainly the one about not allowing men into women's sports. Well, let's not talk about the policy either side of it, but the impact on schools is that for our members, many of them at this point, I should say not many, some have been asked by their boards of education to write a policy to go along with that executive order, but certainly contrary to the firm stance, and thank you, State Ed, for taking those stances that the department has come. So it's chaotic. It seems to be less perhaps chaotic because maybe we're getting used to the unpredictability, but still that has been a real factor for our schools this year.
Yeah, and speaking of executive orders, we had that same issue with with DC's order and the president's order on diversity, equity, inclusion. Jeff, can we talk a little bit about that? Because we've seen now a rollback of that. So what was that? What happened with that? So we had an order from them that SED proudly stood tall on. So we thank you for that. So let's talk about that for a minute.
Yeah, I think the key here is that we have state laws and we also have the Dignity of All Students Act. We've determined how individuals are supposed to be treated, whether inside of our school systems and inside the public sector. That in New York State, doesn't matter your background, doesn't matter who you are, what your personal choices are, what you look like, your country of origin, all that. You're entitled to the public service, and you're going to be treated equitably when you're engaging in that public service. It really is that simple. And those declarations where we determined that people needed training to make sure they were doing that right, we were going to defend individuals when they were mistreated or discriminated against, and then make sure that doesn't happen again, that they wanted us to roll all of those protections back. And there were many places that were willing to roll all those protections back. And New York State was not willing to do that. I was in a meeting in March of last year in DC at a legislative conference, and it was commissioners and other officials in state ed departments, and the new Department of Education of this administration was in the room and doing a Q&A, and the fawning over these folks and just trying to ingratiate themselves in the early days was concerning. So we decided to ask a difficult question. And we asked the question, how are you going to use DEI as a filter for federal funding? And they didn't know how to answer that question. Why? They didn't have a definition for what DEI is. And if you're going to take something to the bank in a court of law, you've got to define your principles. And if you cannot define the term that you're against, you will not win in the court of law. And we're very fortunate. General Counsel is in the room here who wrote back of what, there's Dan right there, that basically what you're asking us to do is illegal. It's against our state law. It's against your own procedures, et cetera. You violated exactly how this interaction is supposed to happen in a federation. And we've won pretty consistently in a court of law when those things occur. So I think people feel free again to do what we've done and act on our values and according to the law in the state of New York. And we just encourage folks to, understand we still live where the rule of law presides. And we're not going to back off of that. Until it doesn't, that's where we are going to play the game. And as long as that's the rules, we're going to continue to win.
And Jeff, we thank the commissioner and department for that. I know we all met with them and we were making those very hard decisions. We thank you for those wonderful briefs. And Bob, as a transition to you, I know NYSA and AFT were heavily involved in those lawsuits with DC as well. What does that look like moving forward legally? I think, the
Constant vigilance. That's
Yeah,
what it looks
yeah.
like going forward.
Yeah.
Yeah, it's, you're never quite sure what's going to come out of the administration in Washington. We talked about the chaos and the uncertainty. So we just have to be, constantly vigilant to what's going on. I'm proud of New York State, the State Education Department, and the Office of the Attorney General standing up for equity in New York. We support that. We, as you mentioned, we've been involved in that effort and will continue to be. And it's just an outrageous situation what they're trying to do. They're out there in other states alleging that a DEI program actually violates Title IX somehow. So there's still litigation going on in Minnesota, Michigan, and other states, which is just horrendous.
Yeah, thank you for the work that you're doing, Bob. I appreciate that. And let's talk a little bit more about another topic, immigration enforcement. I know we're seeing, of course, worry about that in many states. And a little background on how immigration enforcement actually came to be. I don't know if everyone knows. It came to be the year after 9/11. So, of course, everyone knows what happened with the attacks on the towers. I was there. I was a fireman at Ground Zero, so near and dear to my heart. And a year after is how and why ICE was developed. And they started working in New York City in response to Ground Zero with NYPD. So New York has had the longest standing relationship with immigration enforcement in the country. So one of the reasons I think, and I talk about this a lot in education, is probably why we have, compared to other states, less issues, I think, with immigration enforcement. But we do have very strict policies. Jeff, I want you to talk about, and Bob, Cindy, Shanell, I want to talk a little bit about the guidance we have with the governor, Commissioner Rosa, and Attorney General Letitia James. Jeff, what is that guidance about immigration in school districts? I know that was developed in January 2025. That guidance is still in place. That's really important for our school districts. And Shanell, I want to see what that looks like in Albany. Jeff?
So it's really interesting that I'm answering this question when General Counsel, who's a co-author with the Attorney General's office of this guidance, is sitting in the room, and our Chief Data Privacy Officer is also in the room from the State Education Department. We're so
You're just in the
fortunate.
hot seat today,
I'm
Jeff.
just in the hot seat. I got
Listen,
I have to
no
answer this
pressure. You better get it right, or
correctly,
they're gonna.
talking about taking their bar exam in this room, and now I'm on the hot seat. I'm taking the bar. Oh my God. This is not my forte, but basically, in a nutshell, it comes down to really three big things. One, the privacy of the students and student records, that you cannot be asking certain questions. You must admit students into your school system without this high bar. You've got to prove this, and this. They're entitled to get started with their education. And that goes all the way back to a Supreme Court decision in the early 80s. You got to get them in there. They can start their education, provide more documentation later. But even that documentation can't be necessarily documented in a place where it can be collected and given to a part of the government or an individual outside of the scope of that student's education to protect the privacy of that student. So that was reiterated in that guidance. Also reiterated in that guidance was the role of the SRO in many of our school districts, that they can't be engaging in immigration enforcement in their role as an SRO in that school district. They can't be detaining students. They can't be questioning students. The things that it just defines their role. And the third one was, how does the school district interact with immigration enforcement when they come to the school district? It's very clear what paperwork they would need to have in order to interact with the student. It comes down to basically a judicial warrant or order. Anything else is going to be defective and not rise to the level where they can get access to a student without parental permission. So it's really clear guidance. I mean, if I understand it, a caveman, anyone can understand it. And it really has worked pretty well in our state. And I've been pretty proud of our superintendents, and we know counsel for the school superintendents is sitting in the room too.
Wave Jazz Convoy. She's here. She's
Wave Jazz.
General Counsel for School Superintendents Association.
Yeah. They've done a wonderful job of doing this correctly and letting us know immediately when something's happened. And when I get the call, I call Dan. Dan calls the Attorney General's office. We have a powwow, or they have a powwow, and they respond to make sure everything is done by the book. I think that's another reason why it works well in New York State, is there's so much cooperation between people in government to make sure this is done right and to protect every individual that resides in the state of New York. We're very committed to that, and it makes me very proud to be a New Yorker. But I think that small network of individuals who is the quick strike force to protect students and make sure things are done by the rule of law and by the book has been very helpful to our school districts. So we haven't had a ton of incidents at schools in New York State because that guidance is so clear and because the guidance is so public.
And Shanell, what does that look like in Albany? I know this is something that districts themselves have to deal with. Cindy, I want you to talk about this. And Bob, what does that look like?
The policy, as you just stated, it is very clear to us. But when you start looking at the actual families that we are talking about, it looks very different. We have students who are not attending school because they are afraid of being approached by ICE, being deported. They have, in some cases, already experienced this from some of their own family members, mom, dad, or any other entity in their family. So there is little trust that is there on the family's part. There's so many stories that I could probably tell, but we have some students who have to choose between coming to school or going to work. There's one student in particular that I'm thinking of whose dad was deported. Mom is there with a new baby, and we have this 16-year-old who we are trying to get into the school building. We are going to the home. We are sharing all of the resources that we can do to help. But that child is trying to feed his family, trying to help to feed his family.
Yeah.
So roles have switched. Dad is not there, and he is taking on a larger role than he should have to. So, we talk about immigration and we talk about ICE and, we talk about a lot of things, but what it really all comes down to is the people that we are talking about. And everyone has a story. And we, as the school districts or, just members of society, should and need to be there to help them get through their situations.
Yeah, that's a really great reflection, Shanell, because that's what schools are about, right? Schools are about supporting our 2.6 million school children each and every day. Cindy?
Just thinking from what you were saying and reflecting, I just think about for a minute the impact on the school. You're doing this every day, but it's putting out crisis fires every day. So this takes a shift in terms of how much time that you've had to do to bring up your staff. So you need to inform all of your principals and all of your teachers of what these policies are. You need to then put in professional development training of the highest quality to make sure that your staff is well-trained and is well-versed. So although the policies are clear at the 10,000-foot level, when you get down to a school level, the amount of shifting of resources to make sure that they're at this point is tremendous. And what is that taking away from what schools were designed? And that's why I started out, I think my comments at the beginning, the formulas, the money isn't right sized to what schools are dealing with today. And they are over expanding. I can't, what is on your plate on a daily basis is enough for a burnout in a year's time. So thank you for that work, but it's also,
great.
you need to think about the impact on just one topic, but we've talked about how many today, and it's so complex.
Agreed. And I just wanted to add, there are a lot of staff in our building that go above and beyond for our students every day. It goes above and beyond what their role is. And, they really should also get the credit for the hard work and the love and the care that they put into students every day, into families every day. We have staff that have become very close with parents because they're constantly in contact with them, helping them in ways that they probably thought they wouldn't have to in their role. And none of this comes with an extra paycheck on top of what they're already doing. So, it hits a little different when you understand what we're facing in the world, but when you have the actual families in front of you, it has a different impact on you.
And I think all of these conversations we can talk about them at a high level, but they all impact children. Each and every one of those children in that school building. I have to take a brief moment to our people watching at home. I feel like Vanna White. Your CLE code is 2603. I don't know where the camera is. I see the camera in the back. So your CLE code is 2603. So make sure you have that code 2603. You're going to need that. So let's talk a little bit more about last year's session, because we're kind of in the middle of this year's session. Policy typically happens during the budget or after the budget. So we had some big things that happened last year's session that may be happening this year in school buildings. Raise your hand if you have a cell phone that's near you. Right. What don't our children have near them right now? I know we were all NYSED and PTA were a big part of that cell phone law. As was the other ECB partners. Funny story, we all got called to a breakfast with the governor. She called us and we went into the blue room or the red room. I'm forgetting. Was it the red room, Cindy? I think it was the red room. And she sat us down and she said, listen, we need to work together on cell phones. It's a problem. Let's write a bill. And we kind of started that in October. And we ended up with a cell phone limitation law. Bob, how's that going?
Well, we've heard it's been very successful. Some of our teachers in September said this is like the best start of a school year in a long time. The best start of a school year in a long time because teachers didn't have to be constantly telling students to put away their phones or, so in our view, it's been very successful.
Yeah, that's fantastic. Brian, I know you have children in your home,
We actually,
and your wife is also a teacher, and Brian is also a PTA member. He's got everything covered, so.
I pay Kyle's salary. So no, but as a parent, we actually we had an event yesterday and we were talking about this, and for me, our children had not had phones yet. They have recently gotten ones, but at least at the start of the year they hadn't, and we'd been struggling the last year or so with a lot of peer pressure. They'd come home literally every day. So-and-so has a phone. Why can't I have a phone? Just every single day. And, once the proposal came out, we were able to say like, well, we're not getting you one because come September, you're not going to have one. Nobody's going to have one. But actually it was a really big help. As I said, we ended up we finally got them one, but it is, it's limited to time at home and, occasionally when they're, with friends or with their grandparents. But it has definitely shifted our collective ability to focus on the actual schoolwork, on the actual sports, and not, constantly texting with friends and doing apps and worrying about what are the more nefarious things that they could be tapping into.
Yeah, I agree, Brian. Shanell, have you seen a difference in the high school?
I do. I will say that students appear to be more engaged in the classroom. You don't see students sitting there with their head down scrolling anymore. As an assistant principal, I'm also dealing with less phone issues because they do not have their phones, so they are not using anything like Snapchat or, so there's less bullying on the phone and posting things, because that was one of the biggest things that took up a lot of time as an assistant principal, talking with students and just sifting through those issues with the phone. There are a handful of students that, are not particularly liking the new cell phone law, but we are
Sisters.
working with them
Okay.
to get
Coming along.
coming along. Yes.
And Cindy, from an administrator's perspective, it had to be hard to administer.
Well, we were that one association that kind of took a little bit of a different road during the initial, again, I mentioned a fall survey. So when we surveyed our members at the beginning of last school year, 70% of our members said they were in favor of a school's cell phone policy, but the governor had wanted to roll it out as a statewide policy, one size fits all. And of course, our members are very much about school flexibility, district flexibility. So, as educators, they really thought that maybe a more graduated strategy where you could also use this as a series of rewards or bring it, do it in a way that would fit that school district. Some school districts already had cell phone policies. Lo and behold, I do another fall survey out to the members. Now, 80% of our members say, what problem? So it was like within that year, our membership had a totally different perspective on the cell phone policy and can see quite a bit of difference in their schools.
And Jeff, I know one of the issues was potential costs for pouches or things like that. Are we seeing that? Is that still an issue? Do we have to solve that still from the department's perspective?
I think it depends on the school district, really, the choice they made as far as the policy they're going to follow and what they were going to do with the cell phones with the students. Some have made a big financial investment, some have made a small financial investment. It's been a diverse approach to how to do it. We haven't heard about major disruptions because of the cell phones or massive number of students getting suspended, et cetera. We know anecdotally that a lot of students have done workarounds because they're really, really smart. And some of the adults.
They can text from their computers.
Yeah,
intense.
they figure some things out. I even heard about the Apple Watches worn around ankles so parents could.
Oh my goodness, I have not heard that one yet. That's impressive.
It's just so wicked.
I couldn't imagine texting from your ankle. Are they texting?
Give them an A+ and send them to college.
That's
they're ready.
impressive. That's impressive.
That's some great stuff. And what we've heard at the department a few times is just some uneven enforcement and how, some communities, it's like, we're going to enforce it, and the families are like, yeah, enforce it. And then some people in the community are like, you're really not, doing the full spirit of the law. So some of that will still, what'll be interesting is when people aren't looking a couple of years from now.
What happens?
If people, yeah. So we just gotta stay vigilant, I guess, and stay on top of it. But I think that most of the feedback we've gotten from educators, especially in the classroom, is things are so much better.
Yeah, that's great. From a parent's perspective, I think we had so many calls that, because we were pretty public about this with NYSET, from both sides, good and bad. And I am a helicopter parent. I text my child all of the time. And I freely admit that. I know you guys are laughing because you all know that because you know me personally. And my son, when the law passed, he looked at me and he said, "Did you do this?" With like and I said, "Yes." I said, "Me and Melinda, the president of NYSET, and he knows Melinda very well. We're dear friends." And he said, "You have to stop texting me during the school day. You are the biggest person that texts me." And I paused and I looked at him and I realized, oh my goodness, I'm right. I text him all of the time during the day for ridiculous things. Like, what do you want for dinner? Where are you going for after school? Do you have your sneakers? I am that helicopter mom. I don't need to text him during the day. If he needed his sneakers, he could let me know. If he didn't have lunch, the school would give him lunch. And it was, so from a parent's perspective, I had to realize I was part of the problem. So it was a big, you can kind of come to Jesus moment for Kyle. So it is working well. Let's talk a little bit about universal school meals, because that has been a really big win, and something that was affected federally during COVID. As we all know, the President Trump and the Department of Agriculture had done universal school meals countrywide for a small period of time, and then the funding was lost. And so New York State stepped in, and kudos to Governor Hochul for doing that work. Kudos to all of the advocates, all of our groups. Many of our groups really fought very hard. SED fought very hard. All of our state agencies fought very hard for that. And now our students have, for the second year, this is year 2, last year was year 1, this is school year 2, have had free school meals for breakfast and lunch in all of our school buildings that participate in the federal school lunch program. Shanell, has that made a difference?
It absolutely has. I know when that first started, we would see students, we would talk to them and, ask them, are you, how are you doing? Are you okay? Did you eat this morning? And the answer would be no. I said, well, come on, let's go to the cafeteria. Let's get you some breakfast. And sometimes the response would be, oh, I don't have any money. I was like, well, it's free now, right? And their face would just light up. And, just knowing that they didn't have to worry about the cost for breakfast or for lunch. And I think that that's very telling about the need and how important it is that we have that in place.
Yeah. Brian, do we think it's in this budget? We don't seem to have to fight for it anymore.
No, and actually, I think this is sort of, it's such sort of a feel-good story and success story. Part of me feels like there's not a lot to talk about, but I think there's actually 2 sort of important sort of ongoing implementation issues. The first one relates to the federal government, the other is just the program. So talking about the program itself, it is now universal for all districts, but this has been sort of a ramp up over time where, some districts were eligible for a federal program and then the state had a partial subsidy and we've been going on. And one of the challenges that this, we've talked about how interconnected everything is, because we often use these free and reduced price lunch counts in some of the state aid formulas. Districts that have had universal meal coverage for many years now have had difficulty getting those pupil counts, which then sort of impacts their aid. And so, I'm ashamed to say when my district moved, was eligible and, they got the program, we got the income verification form because they moved away from, you don't have to fill out your FERPL application, but they still need to find out how many people are in what income brackets for this eligibility. And so the form came in and I go, oh, we don't need this. We're not eligible for meals. And I almost threw it out. And I went, oh no, I'm part of the problem. I'm one of those parents that's not filling out the form. And so there has been an ongoing challenge there. And part of the state's move in changing the funding formulas has been to try to rely less on that particular count so that we're not dealing with this. But then the federal piece to it, there hasn't been a ton of change on this front, although some downstream effect from some of the SNAP changes. But the way the state constructed its program, it is a subsidy that basically tops off the federal money. So all the districts put in for their federal program, they get whatever federal money goes towards their meals, and the state covers the rest. And so to the extent that we see changes in the federal program, especially that are cutting cutting those services, and we haven't seen that yet. But if it were to happen, at least the way that the state has constructed it right now, the districts wouldn't see an impact. They would still be getting that money, but it would shift from federal money to state money. And so then there's sort of the question of what does that look like from the state budget impact? Does the state then have to find money in other places and take away from other programs in order to maintain this? And so, not a current significant worry, but just something that is interesting to think about. It's done, it's a success, but there are things that we need to continue to think about to maintain that success.
But we think we're going to be okay.
Yeah.
I mean, children are still going to get breakfast and lunch for the future.
And I do think, I think if there was concern that with the change in administration, this would be one of those top priorities to roll back. We didn't see that in year one. And so it seems unlikely that, we'll see that, but that is always out there.
And this has been a big deal. I was on the steps many, many times advocating for this. I know all of us were. And to hear students come in and talk, and it's so powerful. My son, Jackson, I always tear up when I tell the story. I'm going to cry again. I'm a crier. He was transitioning from his K-8 school building to high school, and he panicked. And I said, "What's wrong?" And he said, there was a student that he had brought in extra food for. And he said, and I'm going to call him John. And he said, "Mom, John's going to different high school. We're such a small school district. We don't have our own high school. We have to send our children out to high school. We tuition them out." And he said, "I don't know who is going to give John food now." And he said, and he really was upset by this. And he said, "You have to make sure someone gives John extra food at lunch." He goes, "Because John doesn't have enough food." And I would tell that story to legislators because our children were worried about this. Our children knew the students that needed extra support. So when we were fighting for this, and it was fantastic that happened during COVID, and then it was rolled back. And then so when we were fighting, and kudos to Senator Hinchey and Assemblywoman Ramos, because they were really, and SED fought for this, and all of our associations fought for this. It was a huge win for children, that, no child is going to be hungry now in our school buildings. And then this year, so the first year was public schools, and then we rolled it out to all private parochial schools as well. So now all schools that are in the federal lunch program, whether you are a public school or a private independent religious parochial school, can qualify for a free and reduced price lunch. So I know some schools are still not in that program. So I think, Jeff, I'm looking at you, and I'm looking at the SED staff and Brian and us, and we still, I think, have to get all of those school buildings that are eligible into that program, because it does take a lot of coordination, Brian, and it takes work. So I think that's something that's on our advocacy list moving forward. I know in another hot topic is recess. And there's some bills about recess right now that are popping around. Do we think that's going to happen? Mandating the minutes of recess. I know some of us have positions. We passed a resolution, PTA, that says every student in New York State in elementary school should have a minimum of 20 minutes of recess, or in middle school or high school should have at least 20 minutes of unstructured time. I know all school districts do not have at least 20 minutes. Some have 10. What are the positions about recess? Do we think there's going to be a bill passed mandating a minimum of recess, Cindy?
I'm not so certain that this would be the session for that to happen. I think it's a little bit of a convoluted answer, but certainly with universal pre-K being expanded, I know this is a little bit of a stretch, but so much of early childhood is all about developmentally appropriate and what we think that children need, and certainly play is a big part of that as well. So again, you can't talk about one issue like recess without talking about how it impacts all of the grade levels. But certainly, our membership has always been the need for students just to be, in a situation where they can play and use their time as they see fit.
Yeah. Any other thoughts on recess?
I'm going to say that I'm glad the topic came up, because it's good for school districts to reflect on what their master schedule looks like and what their expectations are for students in a school day, and how important it is for them to also be just humans and not just intense learners who have to meet certain standards. That's important. But we also want to maximize the time we have with the students during the day. I did want to point out, though, that You guys have demonstrated the importance of the individual because they had to do an entire state law around cell phones because of Kyle's misbehavior. And they had to do an entire law around child nutrition because of Brian's misbehavior. We'll figure out who else is misbehaving. We'll pass more laws.
Exactly, Jeff. Yeah, I had to write a law for myself.
Well, I was going to say my penance for all that misbehavior is the work that I did on our instructional time requirements when I was with the department, which touches on recess, which you could do a whole day symposium on. But just another interesting area where there's a lot of interconnected pieces, and instructional time for various reasons fell under the purview of the state aid office. And so if you go back through the Regents records in 2017 and 2018, you'll see a lot of discussion about this. And I think we've seen a lot of outgrowth there. And if you're interested someday, you can ask me why districts now only have 2-hour delays in New York instead of 1-hour delays. That's mostly my fault, and which I'm now paying penance for because my kids only ever have 2-hour delays. But yeah, I think these are all interrelated in ways that it is these things are very important, but they're also not simple answers of like, oh yes, of course, let's do that, because there are other implications when we make those changes.
Yeah, Bob, thoughts on recess? You think it's going to happen?
I don't know if it's going to happen. It didn't happen last year, right?
Yeah.
So I don't know what's changed. I know the NICEAD president, Melinda Person, is very interested in
She is.
recess. And
yeah.
I just know my own personal experience. I like to take a break, make sure I get a walk in during the day, whether I'm
For
in
sure.
the office or working from home. So it's, I think we'll be looking for it. I don't know if it's going to pass.
Yeah. Jeff, I'm going to put you on the spot.
Hello, everyone. Clap once if you can hear me speaking. Thank you. Clap twice if you can hear me speak. Fabulous. I love this. All right. All right. Good morning, almost afternoon, everybody. My name is Chell Miller. I am the program director in the Government Law Center, one of the co-sponsoring organizations here. I work very closely with our staff, as well as staff throughout Albany Law School, to put on events like this. I want to first thank, the Government Law Review, all of the students, who are helping put on today's program, especially Jessie, Sullivan, and Konrad, who have been, doing so much work behind the scenes to get this going. This morning, Pat mentioned our Government Law Center Fellows program and the Government Law Review students. For those of you who are in the room who are Government Law Review members or Government Law Center Fellows, would you please raise your hands? All right, raise them up. Thank you. So those of you who are not, or who don't know these students yet, please feel free to introduce yourselves. These are all students who are interested in careers in government, public policy, public service, who are really fantastic. So I highly encourage you to say hi and introduce yourselves. I have a little bit of housekeeping before we get started, before we announce our speaker. Thank you to Administrative Services and Janitronics staff for getting everything set up for us. There's a lot of stuff that goes on behind the scenes, and I'd be remiss if I didn't thank them. There are restrooms on the first and third floors. There are stairs and an elevator to access those. There is no bathroom on the second floor, apologies. So we hope you'll stay with us for the full day, which will conclude with a networking reception, a really great opportunity to meet each other, meet some of the students who have been here behind the scenes, and some of the panelists as well. So the next panel is going to start at shortly after 12:30. So I recommend starting to make your way upstairs at about 12:20, 12:25, just so you know. So without further ado, I am very pleased to introduce Dr. Ann Sullivan, Commissioner at the New York State Office of Mental Health. She's been in this role since 2014, correct? She's responsible for implementing the state's mental health initiatives with all of the fantastic staff at OMH. As you know, the Government Law Center focuses our programs on the role of government in the lives of vulnerable populations. We are really honored to have Dr. Sullivan here today as someone whose career spans, mental health, psychiatry, and public service. So please, round of applause for Dr. Sullivan.
For you.
So this is on?
Yeah, we're on.
Oh, I'm on. Okay. Hi, good afternoon, everyone. And before I get started, I just have to say a huge thank you to your director. I'm not sure where is, because everything I'm going to be talking about began when your director, Patrick Wildes, was part of the team at the government and was the Assistant Deputy Secretary for Mental Hygiene. And it wouldn't have been possible without you. And it wasn't just that he shepherded it through, he was part of the vision of what we've established across. And I can't thank you enough for that, Patrick. So everything I'm saying, let's give a round of applause. And honestly, I'm not just saying that because I'm here today. It's real. So thank you. I'm going to talk about mental health and for youth. And so I'm going to go quickly through just some of the issues in terms of the prevalence of mental health issues, et cetera. Then I'll be talking about the state's approach that we've taken to dealing with mental health issues across the state. Obviously, this is a huge priority for our governor, and I'll go into all that in a little more detail. But just to give you an example of why mental health is so important, give you some of the numbers. The first thing I just want to mention is something called ACEs, which are adverse childhood experiences. And I don't know how much you guys know about that, but this was published. The data on this goes way, way back to almost the 1990s, early 2000s, but there wasn't a lot of attention paid to it. And ACEs says that basically adverse childhood experiences, things like neglect, abuse, if you can be expanded to even things bigger than one on these charts, which are poverty, unemployment among the family, stresses in the family, not only have subsequent issues for individuals on mental health, an increase in mental health issues if they have it as kids, and an increase in substance use issues, but an increase in physical health problems. And they did very careful studies on this, and it shows that there's an increased incidence of diabetes and cardiovascular problems. So the message here is that prevention in mental health is a big issue. And prevention in mental health is just as important as prevention in physical health. We talk about a lot of physical health prevention. Even though vaccines aren't as, accepted now, we know that that's a major prevention. We know in kids, being healthy and getting sports and exercise is important. Well, mental well-being in kids and mental well-being in families is just as important. And without it, you get these sequelae over the years. So what does it add up to? This is just to add all the other factors. These are those social determinants of health that everyone's talking about. They also impinge very greatly on families and on kids' mental health going forward. And that's why I'm going to be spending like a third of this talk talking about prevention and some of the things that we are doing for kids in addition to the services that we provide. COVID seems like it's a long way back now to some of us, but it isn't over for our younger generation. We have to remember that for them, the post-COVID experience was really a couple of years of a decrease in social ability, an increased use of technology, which we're probably still dealing with now, and I'll talk about a little bit later. And this number, which is often kind of not paid attention to, in New York State, 4,200 youth lost a major caretaker during the COVID pandemic. And there's been tons of studies about the impact on youth when they've lost a parent or a major caretaker. So that's the tip of the problem. But then you get into all the social disruption, et cetera. So we know that this has affected our youth. And we know that post-COVID, there was a lot of increase in adolescents in emergency rooms with suicidal ideation and suicide attempts, particularly among young girls and particularly among Hispanic young girls across the nation, not unique to New York. So the numbers that can connect to COVID are really critical in terms of the way we see working in our communities. And you have to remember that where was COVID hit the hardest? It was in the underserved communities. Okay, next. The challenge is, just to give you some of the numbers, the disease burden is 15%, which is very high. It's the third leading cause of death with suicide for kids, young adults 15 to 29. And just so you know that 40 to 50% of all mental health issues that someone's going to have appear in the adolescent to early adult years. By early adult, I mean 18 to 20. So that means that there's a perfect point here to be working with our schools on intervention, with our families on intervention, because we get all the hallmark prevention signs in those earlier years. These are just some of the numbers, just to let you know that it's been published all over the place, the amount of depression, the amount of anxiety, the amount of kids that are dealing with these kinds of issues on a regular basis as teenagers and young adults. So with numbers like 16% have anxiety, numbers like depression, substance use, very high. Depression, 8%. 8%. That's very high. So what we're talking about here is mental health diagnosis, but also stress among our kids and also prevention. And what the Office of Mental Health has tried to do is have an approach to all this that we can use to deal with the services we need, the prevention we have, and then to work with very complex individuals. And that's kind of where our strategy is. So, youth mental health. Just want to go over this for a minute. These are the guiding principles that we use at OMH. And it took some time to kind of distill these down. And the first one is integrated care. And that means that if a youth has a substance use problem, if they have a mental health problem, if they have a physical problem, if they have a developmental disability, that we should be able to serve that youth in one place and in a setting where they can get all the services that they need. Our system is not always that good at that, so that's something that we're working towards, and we've got some increased special programs for this, but it's something that we are increasingly struggling with, but increasingly getting better at. Because the youth, you can't go in, illnesses don't have one door for anybody. You have to have this kind of comprehensive approach. Diversity, equity, and inclusion is critical. I mentioned before Latina adolescents and having a problem with suicidal ideation. Well, there's an evidence-based practice which was started in New York City called Life is Precious, where for young Latina adolescents who've had suicide attempts, it's kind of a combined after-school program, also working with their mental health provider who's in a clinic. Life is Precious has had great outcomes with those young women. So what did we do after we found out that this was really successful? Is we said, okay, let's spread it from Brooklyn to all the boroughs in New York City, and then let's spread it to the Latina communities across the state. So we now have Life is Precious in Poughkeepsie and in Yonkers and in Amsterdam. And we're building that program across the state wherever we have that population that needs that service. So you have to pay attention to special populations. Every population isn't the same, and the need varies. So that's something the state is always looking at. The next is lived experience. You have to have the input of the youth themselves and their families. This has not always been done as well as it needs to be. So I'm going to be talking about some of the input that we got in the beginning of the planning for the services that we've put up, but also the ongoing input that we have from youth and families about the services we provide. It has to be individualized, and that means that sometimes we have a lot of different kinds of services. People sometimes say, well, why do you have all these different teams that work? Because there's no one size fits all. And you have to really design a system so that you can encompass as many individuals who need the help as possible. And then the last thing you have to have is continuous, ongoing, initial and ongoing community engagement with what you're doing. So This is community engagement. I'm not going to go into it in great detail, but in the orange box and the yellow box are the key things here, which is connection to families and connections to youth. The governor, about 2020, I think it was 2021, 22, 23, did a listening tour across all of New York State. And it was a listening tour that we went to different high schools. She had a big center in New York City that we came together in. And we listened to high school students, parents, providers about what youth needed. And what came out of that was an importance of the voice of youth and families. So we have a youth advisory board and we have a family advisory board. But we also looked at all those recommendations. And to summarize these recommendations, the kids were asking for three big things. The first thing they wanted was access to care, good access to care. And for them, they said very clearly they wanted it in schools. They wanted to be able to get it and not have to worry about paying for it. And they just wanted to have access to care. The second thing they wanted were some safe spaces in their schools where they could come together after school or maybe on weekends, come together and do things kids do, normal activities, but also have mental health supports there available for themselves and their families. And then the third thing they said was that they wanted to have the ability to talk to each other. Because where does a kid go often when they are stressed or having a problem? Who's the first person they talk to? It's their friends. And they didn't know what to do when a friend came to see them. And if you can remember those three things, as I talk about what we're putting in place across the state, I think you can see how we've tried to listen to what they said and how we're trying to put in place the kinds of services that they need, but also that important thing of how to talk to each other, which is in this year's budget, which we're really, really excited about. So the main thing here was then to say, what kind of services should we be developing? Oops, oh, thank you. What kind of services should we be developing? And we strategically picked three buckets. The first is prevention. I'm talking a lot about prevention. The second is access to care. And the third is special services for the very challenging, complex needs that some youth and families have. And so the strategies that we built out in terms of service delivery covered these 3 points. And we're still building it. It's not done by any means, but we're still building it. But it's within those 3 buckets. So in prevention, I just want to mention this because then I'm going to go into mental health specifically. But if you've been listening to any of the governor's speeches about the budget this year has a lot of family service and social determinants of health dollars in it. They're not just for mental health, they're for everybody. And that's a critical thing. And not only are they in it, they're a major emphasis. So, for example, there's childcare pre-K going to be being pushed out, universal childcare across the state, getting pretty close in New York City. By 2028, the governor's goal is to have universal pre-K for all 4 pre-K 4-year-olds. And then go down, get more and more, and eventually get to universal pre-K. I think that is incredible because that offers, first of all, the relief to the families. The average, probably you guys who have kids know, but the average cost for a family is $20,000 a year for childcare costs. That's, first of all, it's untenable for many families. But secondly, it's increased burden of stress on everyone. It affects the workforce because women aren't working because it's better to stay home than to work. So there's a lot that's going on here. That's a major, when you put these things in the social world, it has an impact on mental health and everything else. The 5-year plan for housing was for 100,000 affordable houses across New York State. The state's accomplished 77,000 of those. And the governor put another $250 million in this year to make sure we got to that 100,000. 100,000 affordable homes across the state. That takes away that stress, not just for us. We have lots of supportive housing in mental health, but there's also this housing just for the general population. To look at funding for affordable homes, to look at tackling the rising insurance costs of auto insurance and home insurance. So these things are not, when they're in the budget, they don't directly go to mental health, but when you have a system that's working on multiple social determinants, it has an impact. So now let's get to mental health, which is really exciting. So if you're going to do prevention, where do you want to focus? And we decided to focus on two areas: pediatricians' offices and schools. Why pediatricians' offices is because everybody goes to a pediatrician when they have kids. And often families are much more comfortable talking about whatever stresses they're having, concerns about their child, or even family stresses with the pediatrician than they might be as a first stop to go to a mental health professional. So pediatricians' offices are really, really important. So I'm going to go into these healthy steps. What's healthy steps? Healthy steps is having a mental health provider in a pediatrician's office that is there to work with families, to screen families, to talk with families. You don't have to have a mental health diagnosis. You can just be under some kind of stress. Or how do I work with my 5-year-old isn't getting away with along with my 3-year-old, and I don't know what to do. The mental health professional there is there to work with families 0 to 3, those really early years. And we've been able to have healthy steps grow across New York State in the Medicaid program now by another year or two, I think it's another year, 300,000 families will have access to Healthy Steps. Healthy Steps is an evidence-based practice that pediatricians love. So we've been putting that in pediatric practices across the state. Now, you can't get everything into everybody's practice. So we've established something called Project Teach. And Project Teach is a remote consultation for a pediatrician with a child psychiatrist. So they can call the child psychiatrist can just be I just want to talk to you about this. It can also be a remote consultation where the child psychiatrist actually sees the child and sees the family. That's remote. We pay for it. Any pediatrician can call, and thousands of pediatricians are signed up. We also do various training sessions, but they don't have to be a part of that. They can just use the consultation service. Recently, we've expanded it to maternal mental health so that OBGYNs can call and get information. You know, there was a study done on mortality of moms at the prenatal and postnatal period in New York State. And when they looked at the cases, there were several of those individuals who had been on antidepressants, who were stopped during pregnancy, who later did not do well. And there was actually a mortality. Why? Partly because of many people in the field not understanding what is safe to do during pregnancy, that every antidepressant doesn't have to be stopped during pregnancy. So having this consultation available when someone has a mom who's going to have a baby and they may be depressed, what do I do? They can call and they can get advice, and they can get good advice, and they can also get a consultation. So, and we also have collaborative care, which is basically in adult units, over 2 million adult primary care practices, over 2 million screenings a year for depression in adult primary care practices. So we're very excited about this connection of mental health to physical health, integrated care, making sure that everybody's thinking of the whole person. And then the other area of prevention is school settings. Now, a number of years ago, this was before the governor's big initiative, New York State was the first state to require mental health education in schools. Believe it or not, it wasn't required in schools pretty much anywhere in the country. Some were doing it, but it wasn't required. When that began, and I can just say that was probably about 8 or 9 years ago now. Now, I don't know if any of you get these kinds of exercises, but my grandkids come home with exercises about what did they do with their angry feelings. When I was in school, you never talked about angry feelings. And then as they get older, it gets more and more sophisticated. So that's really cool. So what else do you need to do in schools? Because you can educate in the curriculum, but there's a lot more you need to do. And one of the things which we're really excited about, which is in this year's budget, is something called Teen Mental Health First Aid. Remember I said teens wanted to know how to talk to each other? Well, what Teen Mental Health First Aid is again, an evidence-based practice which has been used across the country where teens learn about mental health, they learn for themselves, but they also learn how to talk to their friends at a certain level about these issues and how to refer and when to say, you know, maybe you need some help, to feel comfortable with talking about it. Teen Mental Health First Aid, it's not an hour course. I think it's like 7 or 8 hours, and it takes a fair amount of time. But we're going to make it available to every sophomore across New York State. That's really exciting. If you think about it for a minute and you think about prevention, and we can do that. If we can have every sophomore begin to think differently about mental health, what that means is for the generation after, when they're adults, what the kids would say to us was that they could talk to their friends. Sometimes they could talk to their teachers, although not too much, but they rarely could talk to their parents. And when they tried, the parents just didn't seem to understand. So I think if we start early with our youth, thinking that this is something you can talk about, something you can get help for, it can have a major impact on stigma and a major impact on future generations. So that one's really exciting. Then we do some very special peer-to-peer. This is primarily in the Syracuse area, but we're expanding it now. We're going to be doing some of it in some of the New York City schools, something called Sources of Strength, where peers, a certain number of peers in a high school get specialized training, and they become available to work with other peers in the high schools, called Sources of Strength. It's focused on bullying, it's focused on suicidal ideas, it's focused on depression. So really exciting. And then the last was, remember I said those youth wanted a safe place to be? So that mental health advisory that we put up, that youth advisory board, we gave them the task of designing something called Youth Safe Spaces. And then we got some money to make safe spaces. So currently across the state, we have about 8 programs. This year in this budget, we got another 2. This is what you often do. You incrementally kind of grow. And the safe spaces, some of them are in schools. Some of them are extra dollars that we gave to Boys and Girls Clubs so that they could be very involved in mental health and supplement what they're doing. So we're doing creative things with after-school safe spaces for kids as well. And then the third thing they want to remember was school-based clinics. Any school that wants a school-based clinic in the state can have a school-based clinic. Now, sometimes it's hard for schools. You need a little space, and you also need to be able to work on making sure that your connection with the provider is working, et cetera. But now we have 1,300 across the state, 1,300 school-based clinics, and we're continuing to grow them. And what that means is that youth can get in the school. They like that. And they can also, we're growing it so that if they need services with their families, they can get it. And also if they need special services, the clinic is connected to a provider in the community. So there's that connection. It's not like, oh, we have a problem in school, now we have to find a provider. They're connected. So we're very excited about this continuing to grow, dealing really with the idea of kind of prevention in those 2 key areas. So this is just a lot of what I talked about, but just to add a couple of special more things. In this year's budget, we have, maybe about 2.5 years ago, the governor brought all the tribal nations into the governor's office to talk about their needs. And so we've been talking with the nations over the last few years. And this year in the budget, we got some dollars to give to the nations to use as they see fit. Because remember, nations are, they're independent governing groups. They are not in the state. But we have over, I believe it's over close to 15 across New York State. So now we have the dollars to give them the opportunity to grow something in their schools that they feel will be preventive of the kinds of problems that their youth have, big substance use problems in the tribal groups. But we're really very, very excited. And they have joined with us in this, and we're really very, very happy about that. And then I think most of these other ones I talked about, just to say that we're also going to be giving awards to schools that do a lot of good work in mental health and give them a special designation, a school of distinction. Okay, then the other thing the governor has taken on is those cell phones, those precious cell phones that kids have. And one everybody's aware of was the ban in schools. There was a lot of controversy about that, but it seems to have gone well. Most schools love it. The teachers seem to like it. And the kids don't seem to be protesting at all. And it seems to be working. But there's 2 other areas, which is to safeguard issues, particularly on the social media and on the addictive games. So was passed last year was a bill to be sure about privacy rights and get rid of those addictive feeds for social media. This year, there's a bill that will do that for the games the kids play, which is separate from social media. Also privacy rights, et cetera, for kids relative to giving them always automatically the highest privacy settings. ongoing, something you have to look at. There's a lot of controversy about now AI, when people are looking at that as well and how that can affect youth in terms of getting on some of these chats. So controlling that so they can't use AI with kids, various kinds of things that are going on. So the second bullet that I brought up, remember, was access to care. And I'm not going to go through all of this, but just by the length of the stuff that's there, I hope you see the investment in expanding the access to care. So if you get past prevention and someone actually needs services, how easy is it to get those services? We have something in the state called Certified Community Behavioral Health Centers. We had 13 in the state before. We have now expanded to 39. What a Certified Community Behavioral Health Center, it serves people lifespan, so a lot of services for kids, but it also has outreach services, has crisis services, makes sure kids are connected to, and adults connected to primary care. And the beauty of it is that we keep an eye on it. We make sure that they're doing what they're supposed to do. And we've had tremendous success with these CCBHCs, and that's why we're expanding them. And it's one of the few things that the federal government is bipartisan about. Thank God. We were concerned that with all the cuts at the federal level, there's a match here, a federal match, which helps you to go to cost. And so far as we know, we still have that will go forward into the future. So there is that appreciation of how helpful these are. And in New York State, we're doing one of the biggest expansions in the country of certified community behavioral health centers. They basically help with financials. I won't go into, they're cost-based, which helps a lot. So basically, the certified community behavioral health centers, we've also expanded our clinics. And then I just want to talk a little bit about Youth Act. ACT, for those of you who know the mental health field, has something called assertive community treatment. And that's been in place for adults for many, many years. And it's kind of what they used to call the hospital without walls. So if someone was in a clinic and they kind of couldn't keep appointments, they really needed a lot of outreach, they really had trouble connecting to services, they would have a team, mobile team that would work with them indefinitely, until they were able to, maybe forever, but until they were able to really connect to services. Very successful. It was never used with youth. A couple of years ago, we decided to see if we could adapt it to youth. And why is that so important? If you think about it, for a while we were having a crisis of youth in emergency rooms who didn't need admission to hospitals, but there wasn't anything that could wrap services around them quickly, anything that could really provide that kind of coordinated care that they needed. So we came up with Youth Act. And Youth Act has now 42 teams across the country. And just to give you a little bit of, we're monitoring, and this was in the first tranche of people we've had in ACT, these decrease in problematic behaviors, decrease in suicide risk, decrease in danger to others. So these are kids with high needs, and ACT is having a good outcomes. So, and just to say that all these things I'm talking about, we're measuring the outcomes. Now, some of them haven't been around long enough to get these outcomes, but Youth Act, we're beginning to get it. So Youth Act, and in certain parts of the state, has significantly decreased the number of kids waiting in the emergency rooms, which is really exciting. Just want to mention this. I won't go into it in great detail, but a lot of what I'm talking about is Medicaid and Medicaid services, but they're not the only payer in the world. And there's an entire middle class in New York State that needs access to services. And that commercial insurers were not always that friendly towards behavioral health services. Let me put it that way. If you look at the second box, mandating rates for our clinics. You know, we have a big community-based provider clinic system. In New York, before this legislation, I would say 75% of those clinics were getting paid by commercial insurers less than the Medicaid rate because they wouldn't sign contracts for anything higher. Medicaid is cost. So that means that we were absorbing costs. We worked with these insurers over the years, nothing changed. So finally we passed legislation that said they have to at least pay the Medicaid rate. So what does that mean? That means in certain parts of the state, like particularly some areas in Long Island, where we have a very high commercially insured group of people, that they can now have access to my CCBHCs and everything else because the insurers, these commercial insurers, are going to have to at least pay the Medicaid rate for services. The other big thing is, and you've all heard about this, was the phantom networks. And this was particularly a problem in mental health and substance use. That basically providers, and if any of you have ever had trouble, I get calls all the time that someone couldn't find a provider. Do you know anybody I can refer to? Because you'd go into those network directories and you'd call one person after the other and they'd all say, well, I'm no longer there or I'm full. I can't see anybody. That's an insurer's responsibility to take care of. So basically, we passed legislation, and this became effective July of last year, and we are monitoring this closely. So if any of you have any comments about this or any problems with it, let us know. You have to be able to get a mental health appointment within 10 days for a routine mental health appointment. An insurer can't put you on some kind of list, and this is mainly the commercial insurers. They can't put you on it, they have to get you. And if they can't get it in their network, they have to get somebody out of network, and they have to pay the difference. They can't charge you for the difference. The other is they have to keep their network directories up to date. So we're working with DFS. There's going to be a big campaign about this. We gave the insurers a little time to get ready, but there's going to be a big campaign. It's going to be out there in the public. It's very, very important. And I think this is where, you've got to, when you think about access to care, you've got to think about it at so many levels. There's the level of Medicaid and all the services that we want to do for the individuals, but there's also commercial insurers and the access to some basic care, especially when it comes to behavioral health. So this has been helpful, we hope, and we're going to be monitoring it. And if anybody has any trouble, we have something called CHAMPS, which you can call, and there's lawyers on CHAMPS who will help negotiate and make sure that you get what you deserve. Okay. So complex care is just the last night. I don't know how much. Looking for the time. Just to say that all that is good, but then there are individuals who need more intensive services. And one of the big things here is making sure that some of the very complex cases that we see get the care that they need. The highest level is inpatient. And post-COVID, there were a number of beds that were closed, including some child beds, across the state because they were converted. Remember during COVID, beds got converted to med-surg beds under the pressure of admissions. Various systems were not thrilled about reopening those psych beds, but the governor stood firm and those psych beds have been reopened. The rates for kids' beds were significantly increased a few years ago. So we actually now have people opening new child beds. Now, you don't want kids to be going into hospitals if they don't need to, but if they need to, you want to have the access. So I think we're getting to a point where we have good access on the child inpatient side. Home-based crisis intervention for youth is a really very special program. It's 4 to 6 weeks of someone in the home with the family, 5 days a week, working with them on the problems that they're having with their kids. The biggest reason that sometimes kids get admitted or even get into emergency rooms and get stuck is the family just feels they can't work with their child anymore. They've tried, they're fearful, they're worried that the child isn't going to do well, they need help. This gives you in person, right there, help, right on the spot. Again, has had a significant increase in getting kids out of emergency rooms. And these are some of the results, that 94% of the kids were able to be in the community. They didn't need that hospitalization. They didn't need that time away in a residence, that they could be worked with if you have that kind of support for the families. Very important. And then just to mention, to go back for a minute, we also have special teams because one of the other groups that are particularly difficult sometimes for the system to handle are individuals who have developmental disabilities and mental health. So we have developed with OPWDD these specialized teams that will be available for these very high needs kids. And we've also, this is taking a little time to come out because finding beds in communities is always an issue. We have some money for what we call transitional beds. So there could be a place for the child to be for a while with these specialized teams getting ready to go home. And I think that that's something we've been looking for a long time. We've got the teams up and running, but we don't have the beds yet, the transitional beds. Those are coming. They have to be sited. But it's that kind of connection for those very high needs kids that we hope will have an impact. It's a small number of kids that need those intensive services, probably about 200 to 300 kids a year. But they really need all our services to work together. And so that's what we're developing for them. So that's the other big thing. And then the last one that I just want to mention is because this affects the LGBTQ plus community. If you know about 988 and the press that came out. 988 is the suicide prevention line, which is now our crisis line in the state. They had a special button that you pressed if you were LGBTQ plus as a youth, and you could talk to somebody specially trained. It was canceled by the federal government. It took away number 3. Basically, another minute. Okay, another minute. Oh my God, I go on too much. Anyway, in this year's budget, we got for New York State. So that's really exciting. So in New York State, our youth will have a place to call, and they will have it just like they used to, even though it was stopped before. Home-based crisis intervention did well. We have a whole big crisis intervention system. And then this is the last thing I just have to, because, you know, when you're ranked number 1, it doesn't last very long. So I have to say, to get it out there while we're ranked number 1, the Mental Health America did a survey of all the states across the states on 17 parameters, which included child services, access to care, incidence of mental illness, insurance payments, everything. 17 parameters. And New York State, thanks to the hard work of all the providers and everybody we have, was ranked number 1. So it feels kind of good to be able to say that maybe we're on the right track. Maybe we're on the right track. And that all the things that I'm talking about here have a real opportunity to improve the system of care. So I'll stop there because I got my 1-minute warning.
Thank you.
Okay, yes.
Queenan, the Associate Dean for Academic Affairs and Professor of Law here at Albany Law School.
Good afternoon, everyone, and many thanks to Jessie for putting this wonderful program together. And welcome back, and thank you all for joining us for this very important conversation on the current challenges facing that students with disabilities face in accessing education. This could probably be a whole day in and of itself, this topic, but really appreciate Jessie including this very important topic in this program. So the law requires schools to provide children with disabilities with a free, appropriate public education. And of course, you know, schools all over the country are working really hard, including teachers, to really provide the best education they can. Yet there are gaps in the law. And for many students with disabilities, access to education remains unequal and too often conditional. While laws and policies can promise inclusion, the lived reality for many students tells a different story. So today, we are going to explore several critical and interconnected issues. First, to follow up on a conversation this morning, we're going to talk about how current immigration policies and enforcement practices are affecting students with disabilities. And I really appreciate the comments from Assistant Principal Shanell Brown, you know, regarding some of those challenges. So we're going to dive a little deeper into that, including fear of enforcement, housing instability, language barriers, and interrupting schooling, and how that can compound existing challenges for those students. We'll also examine the consequences of inadequate support systems, including insufficient funding, staffing shortages, and limited specialized services, which can effectively deny meaningful participation. And a related issue is how systems designed to provide services can themselves be barriers. And we will look at the disciplinary process and how it can disproportionately exclude students with disabilities. So our goal today is not only to identify barriers, but also to elevate solutions, including policy reforms and accountability measures that can ensure educational systems are inclusive by design, not by exception. We are really grateful to be joined by our panelists, and we thank them for bringing their expertise and diverse perspectives here today. First, we will hear from Professor Adrienne Alvarez, who is with us virtually. We really appreciate you being here. Professor Alvarez is an assistant professor of law at St. John's Law School. He teaches disability in the law, professional responsibility, and introduction to law. His scholarship seeks to reimagine federal disability, anti-discrimination law, and policy. During the 2022-2023 school year, Professor Alvarez served as special counsel to the United States Department of Education's Office for Civil Rights, where he advised the department on its rulemaking to update regulations implementing Section 504 of the Rehabilitation Act of 1973. Prior to joining St. John's Law School, Professor Alvarez was a practitioner in residence with the Disability Rights Law Clinic at American University Washington College of Law, where he supervised student attorneys in special education cases and co-taught the clinic seminar. He also worked as an attorney for Children's Law Center in Washington, D.C., representing parents in special education cases, and as a federal law clerk to the Honorable David Briones of the Western District of Texas. Next, we will hear from Jacob Vertero. Jacob is an attorney whose practice focuses primarily on special education and school law. He began his career as a special education advocate for a law firm in New York City. In that role, he regularly attended Committee on Special Education meetings with parents and engaged in proceedings before the New York State Education Department's Office of State Review. He then decided to go to law school here, and he went on to earn his law degree from Albany Law School in 2018. While he was in law school, he served as an editor of the Albany Government Law Review and was actively engaged in moot court and our clinical program. After graduation, Jacob served as counsel to the School Administrators Association of New York State. He also operated a solo practice focused on representing individuals in special education matters and worked with the law firm Piero, Connor, and Strauss, where he handled guardianship proceedings and trust and estate litigation while maintaining his special education practice. He currently serves as general counsel to Questar 3 BOCES, where he oversees all legal matters for the agency, including special education matters. And finally, we will hear from Professor Amy Saji. Professor Saji is an associate professor of law and the founding director of the Health Advocacy and Collaboration Law Clinic in the Center for Social Justice at Seton Hall University School of Law. The Health Advocacy and Collaboration Clinic is Seton Hall's first medical legal partnership. The clinic addresses legal barriers that negatively impact the health and well-being of individuals in Newark, New Jersey. Before joining Seton Hall, Professor Saji served as a supervising attorney and clinical teaching fellow in the Health Justice Alliance Law Clinic at Georgetown University Law Center. Professor Saji was also a special education staff attorney at the Center for Children's Advocacy, which provided holistic legal representation and advocacy for students of color and students with disabilities in educational matters. In 2024, Professor Saji received the Carolyn Golden Hebsgard Award from Lawyering Collaborative for Diversity. In 2025, she was elected treasurer of the American Association of Law Schools section on children and the law. As you can see, a very impressive and knowledgeable panel. So we're going to start with Professor Alvarez, who's going to discuss how immigration enforcement and some of the current immigration policies and practices impact students with disabilities. Professor Alvarez.
Great. Thank you so much. So today I'd like to talk about a project that I've begun that seeks to understand how increased immigration enforcement affects access to special education. And to order my discussion today, I'll first talk about what I mean by increased immigration enforcement, and then I'll discuss potential ways an increase in enforcement might impede access to special education services for children of non-citizens. So what do I mean by increased enforcement? Well, one of the hallmarks of the second Trump administration has been this increased immigration enforcement. And since the beginning of 2025, we've seen the Department of Homeland Security, or DHS, engage in policy initiatives that have resulted in an increase in deportation and separation of families around the country. First, since the beginning of the last year, the administration increased the number of Section 287G agreements that it had signed with local law enforcement agencies across the country. Now, a Section 287G of the Immigration Nationality Act grants DHS the authority to delegate certain functions of an immigration officer to state and local government through written agreements. So this means that if a local law enforcement agent pulls over an individual at a regular traffic stop and suspects that the person does not have permission to be in the U.S., the officer can detain the individual until an immigration official can apprehend him or her. Now, many jurisdictions had previously signed 287G agreements with DHS. For instance, Rensselaer County signed a 287G agreement with DHS in March 2020 during the first Trump administration, but there have been a flood of new agreements signed during this second administration, such as the one that Nassau County, New York, a suburb community on Long Island, signed last year. The second kind of immigration enforcement that we've seen during this second Trump administration has been the rise of large-scale operations, largely targeting cities where residents tend to vote Democrat, such as Chicago, Portland, and Los Angeles. Most recently, there was Operation Metro Surge, which was a DHS initiative that started in December 2025 to accelerate immigration enforcement efforts in the Twin Cities of Minneapolis and St. Paul, Minnesota. Although within the past few days, the number of DHS officers has significantly dwindled in the Twin Cities, at its height, DHS had approximately 3,000 officers patrolling the streets of Minneapolis, St. Paul, which is roughly about 5 times the number of officers in the entire Minneapolis police force. So in addition to an increase in 287G agreements and these large-scale immigration operations like Metro Surge, in January of 2025, DHS rescinded its protected areas policy. Now, this was a policy that had been in place for over 20 years, and under the directive, DHS agreed not to engage in enforcement actions at sensitive locations such as schools, houses of worship, and hospitals. But with the policy rescinded, there has been an increase in immigration enforcement actions at and around public schools. So for instance, on January 7th of this year, DHS officers deployed tear gas at Roosevelt High School in Minneapolis as students were being dismissed just hours after a DHS agent shot and killed Renee Good a few miles away. Now, according to a lawsuit filed by the Fridley Public Schools, which is a school district in Minnesota, quote, when school was dismissed for the day at Roosevelt High School, DHS agents came onto school property and began tackling people, handcuffed 2 staff members, and released a chemical agent on bystanders. According to the witnesses and video footage, an officer dragged a person on a sidewalk outside of the school, broke out the window of a vehicle, and tear gassed staff and students. Video captured by a student during the incident showed a student appearing to lob a snowball at federal agents. And in response, the agents indiscriminately sprayed the area of students and staff with pepper spray or some other chemical agent. Now, Roosevelt High School is the Spanish immersion program for the Minneapolis public schools, and it's about 1/3 African American and 1/3 Hispanic American. There were other enforcement actions at Twin Cities schools, with names such as Un Mundo Nuevo Children's Academy in Apple Valley, Minnesota, Jardín Spanish Immersion Academy in Minneapolis, and Mis Amigos Spanish Immersion in Golden Valley, Minnesota. There was even an enforcement action at Concord Education Center, which is a special education school at Inver Grove Heights, which is a town south of St. Paul. There, on January 12th, DHS officials arrested a special education paraprofessional in the school parking lot. Now, the effects of these kind of immigration operations has been widespread fear, panic, and trauma for citizens and non-citizen children alike. As a result of these operations, school districts have had to close for a few days. Parents have refused to send their kids to school, and there's been an increase in those seeking online learning. So, for instance, if we take the example of Minnesota, according to the lawsuit that Fridley Public Schools filed, on January 6, 2 days after the attack at Roosevelt High School in Minneapolis, half of the St. Paul Public School Spanish-speaking students were absent, as were 1/4 of its Somali students. In addition, due to safety concerns following the events at Roosevelt High School, Minneapolis Public Schools closed both January 8th and 9th. And these cancellations impacted about 100 schools and 30,000 students. Finally, the lawsuit complaint reports that multiple school districts, including Minneapolis, St. Paul, Fridley, Robbingsdale, Bloomington, and Columbia Heights, now offer online learning options in response to DHS activity throughout the Twin Cities. So how could this climate affect access to special education services? Well, first, I should note that children of non-citizens do not receive special education services as often as children of parents born in the US. Among other reasons, because non-citizen parents may lack fluency in English, may experience difficulties navigating complex federal, state, and local special education laws and procedures, and may lack the social network to effectively advocate for their children's educational needs. There have also been studies that show that in communities that have signed 287G agreements, there was a statistically significant decrease over time of Hispanic student enrollment in these communities. And scholars suggest that many of these students simply move to communities that do not have 287G agreements. But even moving to another school has consequences. For instance, academic performance generally suffers when children change schools due to reactive moves, is what they're called. Changing schools also hinders the development of social networks, and highly mobile students are also more likely to experience mental health problems, developmental challenges, behavioral challenges, and are more prone to dropping out of school. The effect of a reactive move or frequent moves on an immigrant child could be even greater due to language difficulties. Now, children with disabilities also experience negative consequences when they transfer to a new school. So while the federal education statute, the Individuals with Disability Education Act, or IDEA, requires school districts to continue to implement a transfer student's IEP or individual education program from a previous school until the school either adopts or develops a new IEP in consultation with the parents. The case law suggests that some school districts fail to implement the child's existing IEP or delay significantly in the implementation of the existing IEP. Now, rescinding the protected areas policy could likewise impede access to special education services for the children of non-citizens. For instance, if children are not coming to school for fear of being apprehended, school districts may struggle to fulfill what is known under the special ed law as the child find duty. And this is the duty under the statute, which requires states to identify, locate, and evaluate all children suspected of having a disability in their jurisdiction, regardless of immigration status. In addition, school districts might experience an increase of lawsuits due to missed services. For instance, if DHS is apprehending and deporting special education personnel, such as the paraprofessional in Minnesota, children aren't going to get their services. And finally, the COVID-19 pandemic has shown us that there are many challenges to providing special education and related services on an online platform. The last thing I want to note is that IDEA assumes that a public school district would not be able to guarantee a child's substantive right to FAPE without partnering closely with parents to develop the child's IEP. So specifically, IDEA provides parents procedural safeguards aimed at ensuring that they can meaningfully participate in developing the IEP. But what happens when a parent cannot participate in the IEP process because he or she is either deported or in immigration detention? IDEA requires public agencies in these cases to identify what is known as a surrogate parent for the child. However, the statutes and regulations around the surrogate parent were developed to address specific needs of children who were in foster care or who were experiencing homelessness. And the statute didn't contemplate this widespread immigration enforcement or deportation. So more research is needed to understand how disabled children of immigrants in particular will navigate access to their education when their parents are caught up in the immigration dragnet. And I'll stop here and answer questions about next steps, I think, in the project that I have in mind, if there's any interest in the question and answer. So thank you so much for inviting me to participate, and I look forward to hear what other folks have to say.
Thank you, Professor Alvarez. Actually, one just question, I guess, before we move on is, can you tell us what policy changes would you propose at the federal, state, or local level that would most likely address some of the barriers that you've mentioned?
Well, I think there's a few things that could happen. I think one is restating this policy, the protective areas policy, where the immigration officials use their discretion not to explicitly go after areas where sensitive populations such as schools or churches or hospitals were in those locations. But I think really, I think we have to reimagine the way immigration enforcement is done. There's a lot of rhetoric around, many of these people deserve to be deported because they are not here with the proper requirements, or because they have committed some kind of crime. But what a lot of this rhetoric doesn't understand is that many of these people also have American citizen children, and there's a profound impact. Even though someone may have a criminal record, there's a profound impact on a child when their parent is deported, particularly when it's the parent that is the primary caregiver who is going to the IEP meetings, who is most knowledgeable really about the child's needs.
Thank you. I'm sure we'll have some more follow-up for you, but we're going to shift a little bit now. And Professor Alvarez mentioned a couple of acronyms, FAPE, IEP, and many of you probably are familiar with those acronyms, but I have a feeling our next speaker will probably talk a little bit about that as well. So Jacob Vertro will address how school resources and support impacts access to education for students with disabilities. Particularly, I think at some point we'll focus on the context of how students with disabilities are disciplined. So Jacob, please, yes.
Is this mic on? All right.
You're on.
So good afternoon, everybody. Thanks for having me. I'm going to start this afternoon with a question, right? And that question is, when we talk about supporting students with disabilities, what do we mean legally, right? In the world of K-12 education, support is not just aspirational, it's statutory. Under the Individuals with Disability Education Act, support means ensuring a free, appropriate public education in the least restrictive environment for students with disabilities. Under the IDA, that obligation is proactive, right, not reactive. School districts must identify students with disabilities, or my fellow panelists just mentioned the child find. That's a referral to the CSE. Once referred to the CSE, they need to evaluate those students and psychologically and educational testing to determine where they're placed on a functional level. They have to provide appropriate educational services to ensure meaningful progress for students with disabilities. And they need to design individualized programming in the form of an IEP or an individualized education program. And of course, they have to protect disabled students' due process rights. But support doesn't just include those issues, right? It also has to address how school districts are going to respond to students who are struggling behaviorally due to their disability. And that's where special education law becomes particularly complex. Discipline cannot be viewed separately from the other supports that are provided under the IDEA. So with that general framework, I want to briefly walk through how special education law governs behavioral support and student discipline in the K-12 environment, and highlight some places where there's some tension that emerges with the implementation of the laws that are meant to protect these students. So there's two overlapping legal systems at play in New York in particular, right? We just talked about the Individuals with Disability Education Act, and that would be the first. The second is New York Education Law, Section 3214, which is New York statute that governs over suspensions of students within the state. Education Law 3214 authorizes school districts to suspend students who are violent, disruptive, disorderly, and it establishes the procedures for both short-term and long-term suspensions. I think we should also mention that it is well established that students with disabilities are disproportionately suspended as compared to their typical students or peers. Now, the Education Law 3214 reflects a school district's, not just their authority, but their obligation to maintain an orderly, safe school for all of its students and staff. Under the IDEA, a special education student can be removed for up to 10 days without any sort of due process mechanism. That means that a district may legally suspend a special education or a disabled student for the possibility of 1 day, 10 separate times, right? So there could be 10 separate 1-day suspensions. There could be 5 2-day suspensions, or 1 long-term 10-day suspension before a student has any kind of rights or any kind of due process mechanism triggers. Now, and by the way, that's about 6% of a student's typical school year, right? School year is typically 180 days. 10 days is about 6%. For suspensions longer than 10 days, or when a student has reached that 10-day threshold in the aggregate, a school district must conduct a manifestation determination review. And we're going to hear a little bit about that shortly. But in a nutshell, if a suspension of over 10 days is being considered for a student with a disability, the Committee on Special Education has to get together, and they have to determine whether the behavior that the student has engaged in is or is not related, either directly or indirectly, to that student's disability. If the committee determines that the behavior was a manifestation of the disability, the student must be returned to school, and the committee should develop some additional programming or services to ensure that the program is appropriate for that student. However, if the committee decides that the behavior was not related to the disability, that can prolong that for the same rules would apply to a non-disabled peer. So that could turn into full expulsions even. Now, that reflects a key principle, right? Disability-related behaviors are addressed or should be addressed through services and intervention under the IDEA, right? It is not supposed to be addressed through exclusion. In fact, the IDEA's real intention was to encourage inclusion of students with disabilities. Unfortunately, we are seeing how Education Law 3214 is playing into this, and at times, perhaps excluding students at times when they're through reform, we could find ways to keep the students in school. Now, that sounds nice, right? The IDEA wants inclusion, provide supports, provide appropriate interventions to make sure that we can do that. But that concept rests on one really important assumption. And that assumption is that the IDEA seems to presume that schools and school districts have the appropriate staffing and capabilities to implement effective behavioral interventions immediately. If anybody has looked at job postings or the big signs posted out in front of a lot of our school districts, anybody can see that the staff shortage within the school setting is severe right now. It's particularly affecting us in the world of certified special education teachers, school psychologists, behavior specialists, crisis intervention workers, and teaching assistants, and in general, mental health providers within the school setting. So it's safe to say that resources are strained at the moment. And when capacity of a school district is limited, support can become reactive rather than preventative. How does that translate, right? What do we see? Well, we see delayed implementation of behavioral plans for students. We may see some increased classroom disruption. We're starting to see a greater reliance on short-term suspensions, right, within that 10-day window that is permitted under the IDEA, right? So if a student's behaviors are manifesting on a daily basis, eventually the adults in the classroom say, well, I need some breathing room. We have up to 10 days, right? So let's implement a one-day suspension. In a lot of cases, the students that are being suspended are of a cognitive level that, frankly, they may not understand the nature of a suspension, right? They may not know that they're being penalized. So what is the purpose really serving other than to exclude those students from the educational environment? We may also start seeing, and in fact, we do see school districts doing what I call informal removals, right? So we're not going to go through the formal process of a suspension. Instead, we're going to pick the phone up, we're going to contact the parents and say, hey, do you mind coming and picking up your son or daughter? They've been experiencing some behavioral issues today, and we think it would be good for them to leave early, right? As long as the parents voluntarily come and pick the child up, the classroom doesn't have the behavior anymore. But again, the student's been excluded from the school setting. So while the legal framework remains the same, the quality of support depends heavily on the institutional capacity of school districts. So ultimately, the question becomes, how do we ensure that the promise of the IDEA, right? That meaningful support in the least restrictive environment is actually realized in the day-to-day within the K-12 practice. And I'm not going to sit here today and pretend to know all of the answers, but I do want to leave you with a few questions to kind of get us thinking in the right direction. Does the current manifestation determination standard adequately protect disabled student-related conduct and prevent special needs students from being excluded? I don't know. Are behavioral supports being implemented in a meaningful way or just enough to satisfy compliance with the applicable laws? Should we think of school safety and disability rights as competing values or as interconnected pieces of overall student well-being? And perhaps most importantly, when we say that we're supporting students with disabilities, are we measuring that with respect to the compliance with the applicable special education laws, or are we actually considering meaningful access and growth for our disabled students? Thank you.
Thank you, Jacob. So before we move on, same question for you. Are there any policy changes at the federal, state, or local level that you would recommend that would most likely, sorry, my mic is not on. So sorry about that. Any policy changes at the federal, state, or local level that might address some of the concerns you just raised?
Yeah, absolutely. And I think we've seen it in the past, right? For example, we have tenure laws. Tenure laws aren't just out there and intended to, provide job security for teachers and school district staff. They're intended as a mechanism to encourage people to join the profession, right, without fear of retaliation and future termination. I think that with additional funding and incentives to bring more people back into education, because it hasn't always been this way. Right?
Mm-hmm.
When I first got started in education law back in 2009, 2010 was the school year. If a student was exhibiting behaviors, there were plenty of additional adults that could be pulled away from their, whatever duty they may be handling at that time to walk with the student, to bring the student into a quiet setting and work with them until they regulated and then reintroduce them back into the classroom. What we're seeing these days is that there's simply no extra adults in the classroom, right? So I think that attacking the staffing shortage that is particularly affecting school districts, I think is a good start. And once our special ed classrooms and programs are fully staffed, I believe that a lot more could be done with that.
Thank you. Yeah, and of course, this morning we heard about the challenges with resources. And so very important to keep that in mind. So Professor Saji is going to talk more specifically, and Jacob mentioned this, she's going to talk about the systemic barriers and structural exclusion, specifically the manifestation determination reviews and the limitations of that system. And she's also going to propose some ideas for reform, including proactive, collaborative, and restorative interventions to help protect students with disabilities. Professor Saji.
Right. Thank you all so much for being here today, and thank you for the organizers for inviting me to this panel. So I'm going to really focus my talk on manifestation determination reviews, or MDRs. Can everyone hear me okay? Okay. And why in practice they often fall short of protecting students with disabilities. And I'll share some ideas around reform and really focusing on proactive collaborative approaches. And my perspective is shaped by my experience as an attorney representing parents of children with disabilities in special education and school disciplinary matters. My clients were primarily students of color and students with disabilities coming from low income and marginalized families. And they receive special education supports through their individualized education program or their IEPs. And so these plans are supposed to ensure that children get the supports that they need to make meaningful progress in school. So to understand why MDRs are falling short in practice of protecting students with disabilities, we have to really go back to the promise of the IDEA, which is the Individuals with Disabilities Education Act. And just for some context as well, it was only about 50 years ago that children with disabilities were routinely excluded from public schools. It was legally sanctioned. They were not involved in the public education classroom. It was not a place for them. And that was all legally sanctioned. And so the IDEA went into effect to change this. And the IDEA was supposed to guarantee that children with disabilities have a right to the free appropriate public education known as FAPE in their least restrictive environment, which is LRE. And it also created a framework to rely on for collaboration between parents, school districts, and school administrators through this IEP process. So the IDEA essentially opened the schoolhouse gates to ensure that children with disabilities had a right and a placement in the classroom. But another form of exclusion was on the rise in response to this, and that's school discipline. And so in 1997, the IDEA was reamended, and then as well as in 2004 to include the manifestation determination, or the MDR prongs. And that was intended to be a procedural safeguard to protect students with disabilities from exclusionary discipline that's based on their disability. And so specifically when it comes to MDRs, if a student violates a school rule and the school wants to propose removing that student for over 10 days or in a pattern, whether it's consecutively or the aggregate, on MDR, the school has a responsibility to conduct this MDR. And so at this MDR meeting, 2 questions are primarily asked. The first is whether the conduct in question that violated that school rule, that behavior, was it caused by or had a direct and substantial relationship to the child's disability, or was the conduct in question the direct result of the school district's failure to implement the IEP? So if the answer to both questions is no, the school may proceed with the discipline, but they also don't have to. And if the answer to either question is yes, the child cannot be removed from the classroom. And so in short, when you think about MDRs, it's essentially looking at how do we protect students to stay in the classroom and to make sure that they are not subjected to exclusionary discipline based on their disability. That is what MDRs were intended to be. However, when we look at MDRs, and even when they are done to the letter of the law, the fundamental problem that I've seen with MDRs and what my research really explores is that MDRs actually conflict with the spirit of special education law, and they conflict with the IDEA. And so MDRs come down to 3 primary pieces. They are a reactive process. They are triggered only after an incident occurs, meaning that schools have to wait for a child to have a behavioral incident in order to really address and sit down with the team to actually look at that behavioral aspect of what's going on and to really be able to make a plan moving forward. They're also an adversarial process. And so when MDRs are being conducted, in comparison to the typical IEP meetings and the nature of IEP meetings, those meetings are about parents and school districts coming together, a supportive team around the child, and the child's needs are at the center of an IEP meeting. So for parents coming into an MDR, they're used to this idea of this nature of an IEP meeting to be that we're trying to sit down and collaborate together. While we always don't agree on everything in those meetings, the spirit of collaboration is intended through the IEP process. MDRs are really looking at what is the incident at play. It's focusing on those 2 questions, and the students' needs are really the back end of this. It's really focusing on what was the discipline and when can we remove the child. Because when we're looking at the adversarial process in an MDR, it essentially is functioning as an informal discipline hearing rather than the parent and school team coming together to really assess what's the child's needs. And so it's also a punitive process. And so the starting point and this meeting is only, again, triggered when the school has proposed to remove the child for an X amount of time. And so the idea of being able to understand what the child's needs are and supporting them is really on the back burner. And so the focus is not on just the child's needs. And again, it's about focusing on the incident. How do we really address the actual needs of the child when we're focusing on when is the time that we can remove the child? How do we ensure there's not a disruptive classroom? And so when we look at how an MDR is actually laid out in practice and in the letter of the law, it's this reactive process. And like my co-panelist says, the IDEA is about a proactive process. It's about proactive planning. And so when it comes to the IDEA, it's about proactive planning, collaborative nature, and it's all supposed to be about supporting the child at the end of the day. And so when the IDEA, it's supposed to be focused on the child and their needs and finding ways to tailor the child's needs to ensure that they're making a meaningful education. It's also about making sure that in the world of special education law, parents are a fundamental piece of the process and part of the IEP team. Oftentimes in practice, what I've seen with MDRs is that there will even be times where parents are not even invited in some circumstances to the MDRs. There are blatant violations that are happening, especially for school districts that have less resources overall, and there are parents of low-income communities that come from immigrant backgrounds, students of color, with different resources based on their neighborhoods and the school districts that they attend. There's a lot going on the ground at MDRs where sometimes these meetings are not happening. And when they are happening, again, even when they're met to the letter of the law and the school district is coming with the best of intentions, this process is coming too late. And this child at the end of the day is the only one who's really not getting the services that they need, the support that they need. And it really puts everyone in an adversarial system rather than trying to foster the collaboration special education really intends. It's also really difficult for parents to be able to articulate and advocate for their child at these meetings when they're essentially blindsided at times when they are at these meetings. Because of the nature of how special education works and this team aspect and the IEP and the annual meetings each year, parents are coming to the table with a certain expectation of how can I collaborate with the school district? And so parents are walking into the MDR meetings not realizing that sometimes it essentially turns into a voting block. And schools really will be able to come into these circumstances and vote together as a team. And the parent essentially, sometimes these votes are going with 5-1, 8-1, but the parents are oftentimes out-resourced and outnumbered. And so parents aren't prepared at how to advocate and properly support their child in these meetings as well. And so when looking at exclusionary discipline, specifically with students with disabilities, we have to really look at what is like the outcomes of these MDRs. We're not supporting them. They're essentially being further excluded. And exclusionary discipline has significant impacts for children, especially in the health justice context. And so students who, according to the American Academy of Pediatrics, students who are suspended and expelled are 10 times more likely to drop out of high school. And students who drop out of high school are more closely related to long-term health and well-being consequences. And studies show that a high school diploma is actually now an indicator of your overall health and future health. And exclusionary discipline has other long-term consequences as well, especially with increased likelihood of entering the school to prison pipeline. So even though MDRs were created to be intended as a safeguard, they're essentially becoming another mechanism of exclusion. And so when MDRs fail because they are reactive and punitive, the solution and one of the ideas around reform for MDRs is really how do we actually reshift the process to focus on the proactive planning and collaboration between parents and schools. And so one of the frameworks that I've been looking at is really how do we institute what I term a proactive behavioral planning framework in the IDEA process, as well as replacing that without the MDR. And so looking at how do we have an IEP meeting after a child has been identified for special education and really sit down to look at what are the proactive behavioral plans we can put into place. This idea and framework is actually really mirrored after the transition planning prongs around the IDEA, where we look at there's exclusive rights and set meeting times and timeframes as to when a child should begin having transition planning to prepare them for independence, employment, and further education. So how do we mirror that proactive initiative that we already have under the IDEA and now use it to really model for behavioral planning? And if we have this process earlier, once a child has been identified for special education, we can sit down with the right people in the room. So part of the problem with MDRs is oftentimes parents don't realize that if their child has other support team members, whether it's a therapist that they meet with or a social worker that they're working with outside of school, these people should be involved in any type of disciplinary process because they have a different insight and a holistic understanding as to how that child's disability manifests in different ways. And so if we have a plan to actually have this type of planning proactively, we can invite the right people into the room. We can have the teachers, school district administrators in the room with the experts that are working with the child outside of school. Because even though an incident might happen in school, these things are all holistic. So really looking at how do we support the child holistically by inviting input from the outside therapists, their medical partners and providers, family members, anyone that really is able to help distinguish and really provide their expertise as to how does this child's disability manifest in different ways. And that way we can plan for restorative interventions rather than a punitive removal. And this plan should also be something that's revisited yearly, because as children grow up and they are hitting different markers, their disabilities also manifest in different ways. And I think one of the problems with MDRs is oftentimes we are looking at what is the child's disability on paper? What is their classification under the IDEA or on their IEP? And so the IDEA doesn't restrict the process to only be how does the manifestation of their disability on their IEP manifest. It's also looking at how does it, what are their other needs and supports? So while a child might be identified for a specific learning disability like dyslexia, there might be arguments to say, well, dyslexia also can manifest into frustration and impulsivity and a tie with other learning disabilities such as ADHD. And so really looking at the child's needs holistically and really looking at how can we as a team really address these things proactively. And so the goal is really to look at how can we prevent incidents from happening? How can we support the child now? And worst case scenario, if an incident happens, if and when that happens, then we have a plan in place to actually address it. We're not waiting until the incident occurs to put a plan into place forward looking. We're being preventative and we're using an upstream approach. And so by centering the child's needs, we can actually also reduce the reliance on exclusionary discipline overall for all students, not just students with disabilities. I think by really looking at how can we make restorative practices more universal design focused, starting with students with disabilities, because they are in 2025 nearly 3 times as likely to be disciplined than their non-disabled peers. So how do we start with our most vulnerable children and address these potential behavioral challenges before they escalate, and really support them on the front end rather than waiting for the back end? So overall, MDRs are created as a procedural safeguard, but they fall short of this both in practice and in matching the spirit of the law. And reform should really focus on a supportive, collaborative process where we can move from a reactionary standpoint where we stand currently in practice to really that proactive, supportive, and holistic approach.
Thank you, Professor Saji. So your recommendation is, and maybe you could speak just briefly about, for those who may not be aware of what the IEP is, and you're proposing it be part of that, right?
Mm-hmm.
That these be part of that process evaluation, and then proactively deciding in the event that the student needs this kind of support, what support will we provide?
Exactly. So when looking at the IEP process overall, a lot of times when you are identified for special education, the parent and the school district has an obligation to identify through the child find, as we heard today. But sometimes not every evaluation or every need is really being evaluated on the front end. So for a student that is suspected of having a learning disability, you might not be conducting a behavioral assessment or really looking at the different social work assessment or a psychological assessment. You're not getting all of the information you need at the front end of an identification process. And so part of this framework is really looking at how do we address the child as a whole? How do we actually do those assessments on the front end to really have the team come together to bring all the data together? Because what's happening is we're missing a lot of information on children through the IEP process, because we're looking at what's the easiest way to get them identified. I think it also has to do with resources and school retention and not having enough staff to conduct these evaluations. And so I think part of this process has to be, how do we partner with a child's healthcare team? How do we partner with different experts to really try and provide the most comprehensive evaluations possible on the front end, including behavioral supports? Because if we look at the behavioral evaluations and we're able to plan for that on the front end, then we can sit down as a team together and really think about what are the supports that we can put in place, what's the functional behavior assessment or the behavior intervention plan that we can put in place now. Because with an MDR process, if the child is determined to have the manifestation of their disability, then that all has to happen afterwards anyway. So why wait until that process happens rather than trying to sit down together where there's no stakes at this point? If you're planning on the front end, you're not waiting on the stakes of, is my child going to be removed from school tomorrow? So you're taking that piece out of it, because I think that adds a lot of stress on the school district as well as the parent, and it makes manifestations even more adversarial than they need to be. And I think if you take that part of it and you move the process earlier, you're addressing things on the front end, and you're also able to support that child if and when these issues arise.
Thank you. Professor Alvarez or Jacob, any other, you've already shared some suggestions, but are there any other ideas you have for reform that you want to share? before we go to questions, or if we have time? Okay, go ahead. Professor Alvarez, go ahead.
Well, something that both the panelists talked about was proactive planning. And I think there is some proactive planning that can be done on behalf of children of non-citizen parents. For instance, schools can proactively train culturally competent surrogate parents to serve as surrogate parents in the event that a parent is deported. Something that a lot of communities do already is help the parents or non-citizen parents sign powers of attorney to allocate educational rights in the event that they are deported. But those, to the extent that they do not include information about special education, advocacy, these powers of attorney should include that kind of information. So that was the only thing that I thought about after hearing my other panelists.
Thank you. Jacob.
And I just want to reinforce something with respect to manifestation determinations and the adversarial nature of them. So in my role as general counsel for ABOCES, one of the things that one of my duties is when a component school district, one of the school districts within the 3 counties that my ABOCES oversees, I get called to serve as the neutral or the hearing officer in suspension cases, right? So whether it's a typically functioning student or a disabled student, a suspension longer than 5 days results in a hearing if the district wants to continue it past 5 days. What's interesting is that often the MDR meetings, right, these manifestation determinations occur quite literally smack in the middle of the phase 1 and phase 2 of these hearings, right? So we come into these meetings and the first phase is to determine guilt or innocence. Did the student engage in this behavior? We don't care whether it was disability related or not. We just want to know guilt or innocence. Put on witnesses, review evidence, and determine guilt or innocent. Once guilt has been determined, we pack our stuff up. I leave the room. The student and the parents go into another room that's been set up with a separate group of professionals, and it's in the form of a CSE meeting, where they then meet to decide, is the behavior that you just had this actual adversarial hearing on a manifestation of the disability? Emotions are very high. There has just been a ton of evidence and people testifying against your child, right? Possibly using language and verbiage that you don't appreciate. And now you're expected to work together to collaborate to determine whether or not this was a manifestation of the disability, right? And then if it is determined, we sort of come in, we put it on the record and we end it. But if it's not, right? So if it is not determined, we come back and have our second phase where we start talking about penalty. And if we're talking penalty, we're not talking short term, we're talking about exclusion for generally weeks or months for a behavior that some were arguing just moments ago was a result of a disability. So tying that into things that could change, and I think could change rather easily, would be to change the dynamic of how that operates, right? To look at the pattern that we have here, and that the way that intersection of 3214, as I discussed earlier, meshes with IDA and manifestation determinations, and say, can we bifurcate this? Can we do it on separate times, or is there another mechanism by which you've already addressed it in advance, and we know what behaviors are going to be a manifestation in advance and which aren't? Right. Yeah. But yeah, to eliminate that adversarial nature, both at the CSE table as well as the suspension proceedings, I think is critical, because we have to be working, parents and outside professionals working in collaboration with school district professionals in order to meet these children's needs.
Well, and it also relates to what Professor Saji said about the reactive nature of that, the way the proceedings are set up currently. So do we have time for, does anyone have any questions for please, hold on one second. We have a mic. Yes. Traveling. Thank you, Nadine.
Hi, everyone. Thank you for being here. Kate Howard. I've been an attorney practicing in special education law for about 15 years, presented about 30 some odd districts, been in-house at Questar 3 BOCES, not under our current panelists, but Susan DiDonato, represented a BOCES, and also been on the Attorneys for Children panel, special education panel for the New York State Bar Association, and currently work for State Ed, so I had to step down for all those fun outside things. There are a couple of things that I think we might be bearing the lead on that I just wanted to clarify before forming my questions and asking if this is actually what was intended. Some of the discussions, I just wanted to be clear, nothing prohibits a committee on special education from looking at and addressing a child's behavioral needs or supports or developing a functional behavioral assessment plan or support or intervention without any discipline. Again, I've been involved with tons of districts, tons of BOCES, and a lot of times you can see things coming down the road. You have excellent educators. Sometimes you don't, unfortunately, but they can address that beforehand. So unlike how it seemed to be framed, that you're not allowed to address it beforehand, that it can't happen until after the manifestation determination, that's not actually accurate, in the sense that sometimes things are new, things change, there's wraparound. And as we learned from our keynote speaker and earlier today, a lot of things can happen sometimes that are more highly impacted and aren't known until then. But I was wondering about some of the different issues because, again, I think if your experiences have been that people have failed on the front end, are they not convening a correct CSE? Are they not identifying all of the children's needs? Because under the IDEA and the law, they shouldn't, you have to put them in one of the 13 categories, yes, but you look at everything. Like it doesn't negate 504 American with Disability Act regulations, access, amenable, like interactions with community at large. So there is nothing saying that a properly formed individual education program, which is the mandate for every child who is classified and qualified for special education, doesn't address those needs. You're supposed to look at their present levels of performance. You gather social histories, you have input from the parent, you're required by law to conduct a psychoeducational evaluation and determine if you need more. So I'm curious if a lot of your negative experiences with this are so much an issue with the law, or is it with an issue with the actual implementation, the actual follow through of identifying the student, getting the student a plan and support they need, the god-awful shortage of the people we need, even with the best of intentions. I worked with some districts that had amazing deep teams. They had psychologists and school psychologists and behaviorists and social workers, and some had one school psychologist across 3 buildings. So I'm curious how much of this is actually a problem with the manifestation determination itself, or is it sort of an holistic approach or issue that we have? Because I know that I and a number of my colleagues have actually always advocated it to be for a finding of fact, not ever framing it as guilt or innocence, but a finding of what happened, and then looking at what happened and saying, does the kid have an FBA? Did you implement it? What are their needs? What are their supports? Did we see it coming? Did we fail them? Did we not know, but it is part of it, so let's get them a plan and a support in place. And then if not, they're just, being a teenager, having a moment, which does happen, then going in and saying, what is the appropriate penalty? Because I think some of the framing was that the manifestation determination further excludes the student. So that was framed as though whether it's a manifestation or not, students being excluded. And so I'm curious how much of this is that people are ignorant of what's required versus what's required needs to change in your experience. Like, is it that people are just completely ignorant of it, or is it that the law itself needs to change all that much? Or should we maybe try to implement the actual law as written first and then see about changing it? Sorry, that was really long.
Do either of you want to take that one?
But I have a couple, right? So I agree. FBAs absolutely can and should be done in advance when there is a clear need for that. I will also say that with the staff shortage and also just in general, a lot of districts are resistant towards doing an FBA preliminarily, right? It usually does require something to sort of spark it because it requires all hands on deck for a tremendous amount of time. Lots and lots of data has to be collected to develop an appropriate FBA. We also have to recognize not only are we dealing with a staff shortage, but with the current federal administration, and I intentionally selected not to mention this during my presentation, but the IDEA at a federal level has been completely gutted. Okay, if you call the IDEA's federal phone number right now, you won't get an answer. If you send emails to the IDEA staff at the federal level, you won't get a response, or your email will bounce back. It's actually been gutted, right? So New York is handling it, and thankfully New York is robust in this regard. More impartial hearings occur in New York than the entire country combined. Okay, so we do special ed, right? Implementation, 100%. I say it every day, right? I have teams who work with their component districts to develop IEPs because we're the ones that have to implement them, right? So BOCES has the alternative programs, but at the end of the day, we're hired to implement school districts' IEPs. So we're at the table, we're providing feedback and assessment on the child, and at the end of the day, though, the school district puts its letterhead on it, and they're the ones that are liable for the appropriateness. What does that translate into practice currently, especially given the staff, not just staff shortage, but also undertrained staff or people working outside of their practice area? We have TAs who are teaching. We have aides who are serving as TAs, right? TAs is a certified role, right? We have a lot of people who are not as experienced as we would otherwise want to. And what that translates to is you've got a beautiful IEP on paper. It addresses all of the child's needs. You've done all of the assessments, all of the data. It looks great on paper. Now let's implement it. You don't have the staff. You don't have the resources. So what do? You try your best. And at the end of the day, I think that a lot of parents these days, if they were to pursue impartial hearings, would probably prevail. But I'll say now what I said to a lot of my clients in the last few years that I was representing parents. What good is it? You win your impartial hearing, right? You have due process. My child's IEP is not appropriate. I'm going to sue the school district under the IDEA. I'm going to take you to a hearing. I prevail. What are you going to get? If there aren't resources to provide the services in the IEP as it was, and you win compensatory services, let's say. Now, there's still not going to be enough staff and resources to provide the compensatory services, right? So unfortunately, it in my opinion, a lot of it does still come back down to resources, staffing, and training for those that we do have.
Do you want to end?
Yeah, I think one thing that I think about when it comes to the IDEA, and especially as an attorney that represents low-income families, one of the things with the IDEA is about how I should be able to put myself out of a job, right? Parents and school districts are really supposed to be the ones there working together. And one of the things that's really difficult for parents is how to navigate this heavily procedural area of law. And I think looking at, is the IDEA even shaped in a way right now where parents are able to navigate this on their own without everything turning into due process cases, or how we keep escalating things into the adversarial nature. And I think when it comes to MDRs, and one things that I think about a lot is really for low-income parents, one of the pieces of navigating this process is how do I ensure that my child is kept in school? And so they're entering a lot of these meetings not understanding really the type of advocacy that an MDR requires. Because if you think about it, the MDR and how it's shaped and the nature of it is counterintuitive to a parent. If you receive a call from your school district saying that your child has gotten into a fight, and an MDR is going to be conducted, a parent's reaction oftentimes is wanting to make sure that their child is taking ownership of the incident going on. They're walking into these meetings wanting to collaborate with the schools, especially after being used to that IEP nature and the collaborative spirit. And so you're walking in there making essentially the wrong type of argument, and you will lose an MDR in practice. And so I think it's really understanding what is the MDR looking for? What is the information we're really trying to assess? Because a parent might go into these meetings and say, my child didn't mean to do this. If you say that, you're essentially saying, this has nothing to do with the child's disability, where that might not be what the parent's intention is when they're coming to the meeting, but the MDR has become essentially a checkbox where it's these two-pronged questions. We're really looking at the information that the school district provides in these meetings. The school has the resources and the information, and the IDEA has really looked at the school having this information. And I think for parents, there's that unequal power dynamic. And I think school districts a lot of times want to work with the parents. I think that in some situations, what I've seen with MDRs a lot of times is really when it comes down to resource issues and funding issues, where how many people do we have in this meeting that have actually even met the child, where sometimes it will be a special ed teacher that might be sitting in place of another teacher who is dealing with another crisis in the school. And so there's a lot of staff and funding issues going on. And I think all those things kind of compound on each other, where it's definitely an implementation problem. But I think when looking at just like the nature of an MDR and really what is the goal of the IDEA, they're not matching up. And I think that's where just being more proactive and really trying to work collaboratively with the school district is important, because this is an area of law where it's not about parents versus school teachers. We're really looking at children at the end of the day, where everyone sitting around that table should have the children front and center. And I think figuring out a way to ensure the collaboration piece is never lost, and being able for me as a parent attorney to put myself out of a job, that is what we want to see. We want parents and teachers all to work together. And I think right now what's happening is with the shortages and funding not matching up to the child's needs, especially in school districts that are underfunded, when we're going into more litigation or due process hearings, we're essentially pushing the issues down the line. And I think one thing that is missing is that as we kind of go through the adversarial process, each day that a child does not have their special education supports has long lasting impacts on them. So every day is essentially a denial of their right. And that's critical time, especially for children, that they won't be able to receive back. And so a lot of times the parents that I represent, their ultimate goal is how quickly can we get the child back in school with the supports that they need. And so I've been able to collaborate with school districts where a lot of times we try to implement this proactive planning on the front end, or we essentially redo the exact same MDR just to have a checkbox marked off that, okay, we went through this process, even though the first time around the school went through the MDR, they didn't follow XYZ. We just essentially redo it, because rather than trying to file due process, I think the collaboration even amongst parent attorneys and school district attorneys and the school districts and parents is so important in that process, where if we can really sit down and think about what's the goal and the outcome we want that is supportive and is proactive, then we can actually work together. And I think what happens a lot of times is we are so focused on the back and forth of the adversarial process that we're missing that the child's needs every single day is not being met when this back and forth is happening.
Thank you for the question. I think this whole conversation just shows how complex this is, right? And the tensions that with the law and implementing the law and the interpretation of the law, and yeah, and right, and clearly there are times where it is working. Exactly. Yes. But thank you for the question. I don't know if we probably don't have time. Okay. But I'm sure if hopefully our panelists will stick around a little bit and you'll be able to ask the question after that. But thank you so much for being here, and thank you. Thank you. Thank you. Thank you for this.
Thank you, Dean Queenan, and our wonderful panelists for such a great conversation. We will take a brief 5-minute break before we get our next panel started on equity in education. Thank you.
Thank you. Nice working with me.
If you do, I'll get these cards out, you guys. I stuck down there ever. Okay.
Yeah, how does the special education process work?
It is holiday. I believe so. That's how I look at it.
Hello, keep up with all of this.
I mean, if you are here, I'll just give you your chance. Now there are and course that one I have. So but
You don't know how to say the word?
Akwazasu.
I said it close enough. Nobody ever gets it right.
Akwazasu.
It's almost first time.
Beautiful, but I can't, Oh, I'm sorry. Nope, you're fine. I just wanted to make sure I have pronunciation correct. Yes.
That's a PowerPoint. Should I stand here?
Yeah, when you present, you can come over here.
Whatever is.
And so I do have your PowerPoint right here. So you'll just share screen and then click right on it. And Professor Gonzalez is also. Let me ask for.
Our education system has been referred to as, or perhaps an engine of opportunity. We all know that there are many longstanding practices and policies that continue to interfere with equal access to learning. So thank you all very much for what you do. And also, the most marginalized students are the ones that suffer disproportionately with regard to these policies and processes. So I am delighted to introduce today's panel that will be discussing this important issue of equity in education. Our first panel member, Professor Diana Newmark, is an associate clinical professor of law at the University of Arizona, where she directs the Education Advocacy Clinic. Her research and teaching interests include education law, juvenile law, and children's rights. Professor Newmark previously was a Clemenko Fellow and lecturer on law at Harvard Law School. Prior to that, she was a staff attorney at the Children's Law Center in Washington, D.C., where she represented children in foster care proceedings. She also served as the Skadden Fellow at the Legal Aid Society in the Bronx, New York, where she represented court-involved children in school discipline and special education matters. Professor Newmark received her J.D. cum laude from New York University of Law and a B.A. in philosophy from Columbia University. Before attending law school, she taught special education for 4 years in the Bronx, New York. Welcome, Professor Newmark. Professor Newmark will be presenting on school districts' power to expel and critiquing the long-term suspension law. Next on the panel, we have Rohini Singh, who is the director of the School Justice Program at Advocates for Children of New York. Ms. Singh, an attorney, is the director of the School Justice Project at the Advocates for Children of New York, known as the AFC. And for over 50 years, the AFC has worked to ensure high-quality education for the New York City residents who face barriers to academic success. And she focuses on students from low-income backgrounds. Ms. Singh specializes in working with students with mental health and behavioral challenges, advocating for adequate behavioral supports, special education services, and alternatives to suspension.
As director, she supervises the AFC's school discipline and suspension work. Prior to joining the AFC, Ms. Singh worked as staff attorney in the Tenants' Rights Campaign in Legal Services of New York City, and as a staff attorney at Disability Rights DC, where she advocated for community-based alternatives to incarceration for people with disabilities. Ms. Singh earned her law degree at the Georgetown University Law Center and her bachelor's from Vassar College. Welcome, Ms. Singh. Okay. Clarissa Jacobs, a Turtle Clan member of the Mohawks of, and I'm going to try it and you can correct me, Akwesasne. Close enough? Okay, thank you. And earned her Bachelor of Arts and Education degree from Lakehead University in Thunder Bay, Ontario. And also under the Native Teachers Program, and she holds qualifications in guidance and cooperative education from Queen's University in Kingston, Ontario. She also has a certification of advanced study in school counseling from St. Lawrence University in Canton, New York, and she began her career as an elementary school teacher in her home community. She then went on to serve as a Native student liaison at the General Vanier Secondary School and Cornwell Collegiate Vocational School. This position opened new avenues for her because she then became a summer cooperative education teacher and youth career officer with the Ashwenazi Management Board. In 2016, Ms. Jacobs filled the position of the New York State Education Department Office of Indigenous Education Coordinator. She presently serves on the NYSED Indigenous Education Council, My Brother's Keeper, the Bilingual and World Language Advisory Council, and the New York State 215 Commemoration Committee Society, an organization. Next, we have Professor Talia Gonzalez, who is the professor of law and holds the James Edgar Hervey Chair of Litigation. Professor Gonzalez is faculty director of the Center of Racial and Economic Justice, senior scholar in the UCSF-UC Law SF Consortium on Law and Science and Health Policy, and a faculty affiliate with the Center of Race, Immigration, Citizenship, and Equality and Center of Social Justice. Professor Gonzalez is a nationally recognized scholar whose research in restorative justice, education law, health justice, juvenile justice, critical race theory, and adultification bias has been published in leading academic journals, numerous and very long list, including Boston College Law Review, American University Law Review, the Stanford Law Review Online, UCLA Law Review Discourse, and the Georgetown Journal of Law and Modern Ethics, just to name a very few. Additionally, her applied research has appeared in the Washington Post, the Atlantic, the New York Times, NPR, and she is cited extensively in multiple fields. Professor Gonzalez has received grant funding from the Robert Wood Johnson Foundation, Grant Makers for Girls of Color, Annie E. Casey Foundation, Spencer Foundation, and Atlantic Philanthropies. Professor Gonzalez received the National Association of Community and Restorative Justice Research Award in 2022, and presently she serves as the co-chair of the ABA Criminal Justice Section, Diversion and Restorative Justice Committee. She is the vice chair of the board of directors of the Public Health Advocates and chair for the board of directors of the National Association of Community and Restorative Justice. Since 2017, she has held an appointment as a senior scholar in the Center on Gender Justice and Opportunity at Georgetown Law and was previously a scholar in residence at Berkeley Law and UCLA School of Law. Prior to joining the faculty at the UC Law in San Francisco, Professor Gonzalez was the Madeline and McKinney Professor of Politics at Occidental College. Thank you and welcome to all of our panel members. I'd like to give them a round of applause to welcome. Thank you very much.
First, we will hear from Professor Newmark.
Oh, good. Okay, that's better, right? Okay, great. Thank you so much for the wonderful introduction. And thank you, Jessie and the Government Law Review for putting on just such a fantastic symposium today. It's an honor to be here with such a fantastic panel. So I wanted to talk a little bit about my research into school discipline. And my research right now is really focused on the discretion that's afforded school boards overall in enacting school discipline exclusion. So my argument is that the power to expel children, so long-term suspensions and expulsions, that power is essentially held by school boards. And my argument is that that really doesn't make sense, that schools themselves shouldn't really be the gatekeepers of who can access public education. So let me explain what I mean by drawing an example. So as you heard in the introduction, I direct a clinic and we provide legal services to kids in schools. And one of those areas is school discipline. So a year or two ago, we had a client who was pretty young. He was 11 years old, I think 5th or 6th grade. And he had gotten into some trouble. So he, like a lot of kids, and honestly, a lot of kids in Arizona, was sort of interested in guns. And at home on the computer was like just talking to someone online about guns. He wasn't threatening anyone, he wasn't buying guns, but he was talking about it. And like pretty much all school computers that are used for schoolwork, there was AI software that was monitoring this. So his conversation was picked up by the school's AI, flagged for them, and pretty quickly he got suspended for a couple of weeks. This isn't even the problem yet. So he was suspended. His parents are, oh my goodness, okay, they're doing what parents do and they're trying to figure out what's going on, getting him resources. But then he comes back to school and does normal, 5th or 6th grade school stuff. One day in class, there was a free period. Kids are playing with a game, board game type of thing. And he had, I don't know if it was Monopoly or some other game that had little figurines, and he and his buddy are playing back and forth, and they're fighting. So my client at one point says, bang, bang, mine is guns. And all of a sudden things sort of blow up. So the teacher intervenes, the school's already on edge because of the previous incident. And they start initiating long-term suspension / expulsion proceedings. His parents are thinking, wow, okay, I get it, but this is wild. And we don't really want to be at the school anymore. It was a school choice option. They thought, this is not working out for our family. Let's go elsewhere. So far, so good. They go to the school, his neighborhood school, which is the, designated school district and the home school for the student, go to register the child. They look over the paperwork and they realize, well, what, the child was expelled. The parents are like, what? That doesn't make sense. And at the end of the day, they were sort of right. And the school just didn't enroll the child. He had absolutely no school to go to. No other school would take him because state law in Arizona, at least, allows schools to deny enrollment to children who were expelled or who withdrew pending expulsion. And so we get involved, and essentially the only path forward is just begging and pleading various school personnel. There's no agency to step in. There's no court that would review the decision. And at the end of the day, you have an 11-year-old who has absolutely no school to attend. So why am I sharing this? Arizona is obviously different from a lot of states. It's different from New York in some key ways. And there's certainly more legislation here compared to Arizona. But the Arizona example highlights what I think is actually something broader throughout the country, which is that there actually are very few checks on school boards when it comes to discipline policy. And I want to talk about that and why it is that I've come to see the expulsion power as one that's really held by school boards. And I also want to highlight the ways in which this system serves the interests of the schools over the interest of the student, but importantly, over the interest of the state itself. In short, I think that states have delegated their authority over school discipline to school boards too broadly. So what is this expulsion power? I think a lot of folks think, okay, kids have a right to an education, right? The answer to that, there's a big asterisk, it's a little complicated. But a lot of folks would think they have to have some kind of right to education. So if that right is denied and they can't go to school, there has to be a court, right? Like some courts, they do that, right? They enforce rights. They make sure things aren't falling totally through the cracks, or at least they should. So you'd think there'd be a court you could go to. It turns out most of the time, not really. So for the federal court system, there's, as a general matter, sort of an abdication over just bread and butter school discipline issues. There might be some review of procedural due process, but for those substantive school discipline decisions, there's essentially an extraordinary limited, if not no real role for the federal government to jump in through judicial review. Okay, so the federal courts, they're kind of out. Then we're going to look at state courts. So in my research, I've looked at a ton of state school discipline decisions, and I've come to see that there are generally 4 categories of how state courts handle school discipline cases. On the one end, you have the laissez-faire courts. These are courts that have adopted an explicit policy of just deference to school board decision, whether the court themselves feels like this is the right or wrong call. Another group are the school discipline exception states. That's like, in I think Massachusetts and Nebraska are 2 examples where there is a state right to an education, but school discipline is an exception to that. And the courts aren't going to review it. They might review right to education cases when it comes to school financing or taxes, but they won't review it when it comes to school discipline. A third type of court approach is the forfeiture theory, where courts say, yeah, we get it. Students do have a right to education, and we understand exclusion can implicate that right, but kids forfeited their right with their misbehavior. This one makes the least sense to me because it's hard for me to understand how a child has a right to something that's implicated in a proceeding, but if they've been accused of violating a discipline code, then the court's going to not take a close look because the child's forfeited their right. So that's one approach. And then the other one, which is a more robust review, are the states such as Minnesota and North Carolina that have a requirement for reasoned decision-making. So in these states, the court will look at whatever the statutory scheme is over school discipline and say, okay, you know, we might not really agree with the disciplinary decision here. We're not going to tell you to undo it, but if you are not going to follow the statute as it's written, or if you're not going to follow state policy, we're going to ask that you provide a reason for that. So it's requirement for reasoned decision-making. Throughout all of these approaches in the state courts, there's a pretty strong deference to the school boards. It's very unlikely that these courts are going to come in and order the school board to reverse course if the school's already decided that they really want to suspend or expel the student. So then it seems like for that maybe state legislatures would be the ones to provide kind of a check on the school board gatekeeping role. And there is a wide variety across the states in terms of that regulation of the school discipline authority. I already, noted some of the highlights from Arizona, but essentially, I think, I've looked at some of the core areas of school discipline regulation that speak to whether or not a child really gets an education at all. So those would be things like the duration of exclusion, how long can kids be removed, and whether alternative education is provided to them. So there are states where expulsion is permanent. There's no end date, just end of the school's service of the child. And that can also be coupled with no education provided. So some states require alternative services for kids who are suspended or expelled. Some make them available, but there are others that are completely silent. So there are plenty of states where through these 2 mechanisms, there are kids who really have no school, and certainly no public school, that they would have a right to attend. Then there are other ways that legislatures have regulated school discipline authority by thinking about what the basis of exclusion can be. So every state has to follow the federal Gun-Free Schools Act, and that requires a 1-year expulsion with some exceptions for on-campus firearm possession. But other than that, there's not necessarily uniformity among the states. So some that the Gun-Free Schools Act is the only basis for exclusion that's mandatory. Everything else, it's up to the school district to decide what they want to exclude students for. Some have firearm offenses plus a host of other offenses that states require exclusion. That could be serious things like sexual assault, and aggravated assault, or it could be an even broader and maybe more vague definition of offenses, things like defiance. So some states actually say schools have to suspend and expel kids for those infractions. And then on the other hand, there are states that actually limit expulsion. They say school districts, you can expel for what you want to expel for, but it can't be pregnancy or it can't be truancy. They'll have a list of things that they won't authorize expulsions and suspensions for. So as you can see, there is a range, but at the end of the day, even for legislatures that do designate certain offenses or certain time limitations for kids on suspensions and expulsions, usually there's an exception, and a school board could sort of maybe there's a loophole that the school board could try to, at the end of the day, they would be the decision makers for whether a child fits in that loophole or not. So one example for that are age limitations. Several states have limited long-term suspensions and expulsions for young children, like kindergarten through 4th grade. But as far as I've seen, I think pretty uniformly, there's always a carve out for if there's sufficient seriousness of behavior and things of that nature. And when that is the case, it's the school board that decides whether that carve out applies. So courts aren't really providing that oversight role. Legislatures delegate authority in a variety of ways, but usually at the end of the day, it's up to the school board. So my argument is that this system might make sense if a school board could understand all the various interests and balance them appropriately. But my view is that that doesn't really happen. The incentives here are simply misaligned to ensure not just fair adjudication, but just that kids get the services that they would need and have access to school. So in my view, the misalignment of interests is often just too pronounced to justify such enormous deference to school administrators and school boards. And so the story I told you at the beginning really illustrates this. When you think about it, remember that 11-year-old who has no school to go to, this is clearly not in the student's interest. It's really hard to see how having a young child with no school to go to serves their interest in an education, serves their reputational interest. It just doesn't serve their interest. And it doesn't seem like it serves the state's interest either. It's hard to see why a state would want a state of affairs where young kids don't have teachers, curriculum, peers, extracurriculars. Like, it just doesn't really make sense. They have compulsory ed laws, they make kids go to school. They have truancy laws to get in trouble if they don't. So why would they have this situation? It doesn't serve the state's interest. So whose interest does it serve? Well, it serves the schools, right? Like the school that wanted the child out, they were terrified. They were worried that this child was going to become a school shooter or whatever. And they're trying to protect their school community at the expense of the one student. But so was the student's home interest. They had the power to exclude the child, and it certainly was in their interest to do so. They didn't want to take a student in thinking that they might be a risk to the learning environment for their school. So I think this is usually in school discipline, we think about it's sort of almost prosecutorial and defense, like there's a school versus the student. But I think the actual dynamics here are much broader than that. And they include this idea of the state and ensuring that kids have access to education, period, even if it's not at the particular school that's at the issue of the suspension. So in my view, this reliance on school boards to adjudicate these cases just doesn't totally make sense. Something more would be needed. And in my view, I think legislatures should consider shifting the power to expel away from the school board and toward a more neutral decision maker. And I think in New York City, for example, I just learned today, is similar to DC, where the Office of Administrative Hearings actually is the one deciding expulsion cases. There are a few other suggestions I have in my research, and these are just some ideas. So at the end of the day, my view is just that the power to expel really should not be quite so firmly in the hands of the school board for several reasons, but one of those is, of course, equity. And whenever there's such discretion, that opens such a broad door for all sorts of biases to just walk right on through. And I think that doesn't make sense. We know it doesn't make sense in so many other areas of education law. And I think the same is true for school discipline.
Thank you, Professor Newmark. We will now hear from Ms. Singh, who is the Director of School Justice Project at the Advocates for Children of New York, and she will be speaking on the topic of presenting, on advancing educational equity for court-involved students.
Just bear with me a second. I have a PowerPoint, so I'm gonna share. There it is. Okay. I think we're good. Great. Hi, everyone. Thank you all for inviting me here today. My name is Rohini Singh. I direct the School Justice Project at Advocates for Children. And Advocates for Children is a nonprofit legal services organization whose goal is to ensure that every child in New York City has access to a high quality education. And we focus on working with students who face barriers, historically marginalized students that face barriers to accessing that education. And we take sort of a threefold approach to our advocacy work. The bulk of our work is direct legal services. We do special education advocacy. For the most part, we represent students in suspension hearings. We also do a lot of capacity building, so a lot of trainings in the community. I think one of the prior panelists talked a lot about how you shouldn't need lawyers to, get the rights that you have under the IDEA. And so really trying to expand our reach and expand the community's knowledge about the relevant special education and education laws. And then finally, we take what we learn from our direct services work and community outreach and advocate for systemic change, either through policy advocacy or systemic litigation. And I direct the School Justice Project, and our long-term goals are centered around four things. So first, we focus on protecting the rights of students who are being pushed out of school through suspensions, arrests, summonses, or inappropriate referrals to hospital emergency rooms. Second, we focus on decreasing the amount of time students spend out of school due to discipline or school policing. Third, we build capacity both within our organization and, as I mentioned, the community to better support students that are facing exclusion, court involvement, or behavioral challenges. And finally, we push for the reduction of the reliance on punitive and exclusionary discipline in New York City public schools by advocating for restorative justice, mental health services, and social emotional supports that address the root causes and prevent incidents before they actually escalate. And to advance these goals, our casework really focuses on four main groups. So we work with students that are court involved, that are sort of at the end of that school to prison pipeline. We work with students that are accused of or targeted by bullying behavior. We represent students with primarily behavioral needs that need special education supports. So the prior panel was really illuminating and really relevant to a lot of the work that we do. And then we represent students facing suspension. So, and that includes the informal and illegal exclusions due to behavior. And so today, what I wanted to focus on is a report that we released a few months ago on the educational outcomes of court-involved youth in New York City. And just some background, and just to sort of give you a sense of the landscape in New York City. So the attorneys on my team, we work frequently with young people who are court-involved. And the role that we play, we're not a defender organization. We really help families navigate the complicated, New York City public education system and the special education system upon a student's release from a court-ordered placement. And in addition to that, we also ensure that students are receiving their IEP mandated services that they're entitled to while they're incarcerated, while they're in placement. And just to give you a sense of, what happens to a young person when they're arrested and charged with an offense in New York City, after the passage of Raise the Age in 2017, young people who are under 18 in New York City are no longer prosecuted in criminal court when they're arrested, but they're instead they're sent to family court. So from there, if a judge decides that they cannot return home while their case is pending, or if they're found responsible for an offense that they're accused of, then they can be placed in either a secure or non-secure detention facility or in what's known as a close-to-home residential program. It's sort of like a group home. And these facilities are all run by the New York City Administration for Children's Services, ACS. And all students that are in these detention and placement facilities, they're entitled to full-time educational instruction, especially when they are compulsory school age. They're required to go to school. And the way that the instruction is provided in New York City is that the instruction while a student is in placement is actually given by the New York City public school system through a school known as Passages Academy. And this is a public school that's run by a specialized school district in New York City called District 79, which sort of runs alternative programs in schools for young people in New York City. And these schools are either at the facilities themselves or they're at a separate site where students are transported every day to get to school. And I hope this is sort of a given, but court-involved young people have extremely unique and complex educational needs that often predate their time in custody. Many court-involved young people are overage for their grade level. They have undiagnosed or inadequately addressed learning disabilities or mental health needs, or they've experienced significant trauma. And too often, these young people, they continue to struggle to access educational services and supports that could help them succeed, both while they're in detention or placement or after they're returning home. And so we saw this happen in our individual cases and in our work with individual families. But in order to push for systemic change, we really needed to get a better sense of sort of the scope of the issue beyond what was happening in our individual cases. And so we worked with a number of allies in New York City Council, as well as other advocacy organizations, Legal Aid Society, Legal Services, the Bronx Defenders, Brooklyn Defenders, to propose a reporting bill on educational programming for young people in juvenile detention or placement. And we were successful. It took a few years of advocacy, but Local Law 21 was passed in December 2023, and we received the first set of data in 2024. And here's what we learned from the data. So Passages Academy, which, as I mentioned, is a school for students in detention and placement, served 810 young people between the ages of 13 and 20 at some point during the 2023-2024 school year. And in the 2024-2025 school year, they served about 1,040 students. And it's important to note the majority of students served by Passages belong to demographic groups that have historically faced barriers to education. For example, more than 60% are Black. The Black students comprise only about a quarter of overall New York City public school enrollment. Around half have individualized education programs. And in 2023-2024, nearly a third were students in the foster system, which is a group of students who make up less than 1% of the overall student population in New York City. Students with disabilities at Passages are not representative of the overall population of students receiving special education services in New York City. They're more likely to have an emotional disability or an other health impairment classification, which is typically used for students that have ADHD or other diagnoses that sort of don't fall into the other disability classifications. And they're less likely to be classified as autistic or having a speech impairment. And youth in juvenile detention or placement in 2023, 2024, and in 2024, 2025 were almost twice as likely as their peers to have learning disabilities, and more than 17 times as likely to be labeled as students with emotional disabilities. And notably, over half of the students who transferred to a New York City public school or some sort of high school equivalency program after being discharged from detention or placement missed more days of school than they attended after transitioning back to the community. And so what did this data demonstrate for us? You know, to be honest, the data is extremely helpful in sort of seeing the whole landscape, and it is a really crucial advocacy tool for us to push for reform for court-involved youth in New York City. But it really just confirmed what we were seeing in our individual clients and in the cases for court-involved youth. It clearly indicates that we need to do better for court-involved youth in our communities and to really ensure that they're receiving the supports that they need, both before, during, and after their time in detention and placement. And so what does this look like? What does this look like on the ground? So just to give you a few examples or a sense of what this looks like in clients. So it looks like a student like Joshua, who entered detention at 18. He was at a secure detention facility for a year. His mom, was worried about his education while he was there. She got little to no information, never heard from a school social worker or a teacher the entire time he was in detention. And then he was released, and he was released at the end of a school year and was not given a placement, was not told how many credits he had earned while he was in detention or placement. And at that point, he was 19 years old. And the family was told to go to a local family welcome center, which is sort of like an enrollment office in New York City, and to just enroll in his local school. Joshua had an IEP. He had an emotional disability classification. When the parent called, we found out that he had not received any counseling sessions or any of his mandated services while he was in placement. And then when the family went to the enrollment office basically said, you're 19, you have very little credits. We don't know where to place you. Here are some, high school equivalency programs or, like alternate school programs. Joshua is, of course, entitled. He wanted a high school diploma. He did not want to do an alternative program. He's entitled to remain in school until he's 22. When the parent called us, we really had to do a lot of work and escalate this case to get him into a school placement that was actually willing to meet his needs. This also looks like another student, Michael, who's a 14-year-old eighth grader with an IEP classification of other health impairment, who was released from a secure detention facility. And part of the conditions of his release was that he had to be on home detention at the time. And at the same time that he was told he had to be on home detention, he was also given a 48-hour window to enroll in school. And so Michael's mom called us, went to we informed her of her rights, told her she could go to a local, his zone school in the Bronx and try to enroll him. And the school sort of refused to enroll him, said that he needed to be there in person, which is contrary to what the policy is. So the parent went back to the court, tried to say, like, I need went to the sheriff, said I need, approval so he can go off of his home detention so he can enroll in school. Otherwise, we're going to miss this 48-hour window. And it just, he was released under this impossible condition to meet. And the judge had no sense or no idea of what the actual logistics were of what it would take to enroll Michael in a school. Eventually, we were able to get an exception to that 48-hour window. He was able to get back into school. But without, access to a lawyer, without, sort of access to an advocate, the parent would not have been able to navigate the situation. So these are just a few examples. And unfortunately, as I mentioned, the data really helped us understand that it reflects the greater reality of what's happening and that we need to do more for our court-involved youth. And so what are some of our key recommendations here? So our recommendations based on the data and in our experience really focus on three aspects of placement. So there's what happens before. And I think this echoes what a lot of people have been saying. It really sort of dovetails nicely with the presentation over lunch. We want to make sure that students that have critical behavioral mental health services, they have access to reading intervention, special education services in their school communities. Again, with this added goal of preventing contact with the juvenile criminal legal systems. And in New York City, what we've been pushing for and advocating for, especially with this new mayoral administration, is for this to happen in a few different ways. So first, we're pushing for every school to have either a school-based mental health clinic or a partnership with a community-based mental health provider. This looks a little bit like maybe the idea that every school should be a community school. I think we talked about community schools in the first panel. And really we need these programs that can provide expedited referrals and support students that have significant mental health needs. We want the New York City public school system to hire at least one behavioral specialist per school district. There was some talk here about behavioral specialists, and I know that there are, I feel like a lot of people talk about how New York City is very well resourced. I know that there are districts in New York that do employ behavior specialists. In New York City, we have very few, if any, access to behavioral specialists on a school level. And so we want at least one behavioral specialist per district who can provide direct services to students and provide training and coaching for school staff in culturally competent, evidence-based, and trauma-informed approaches for addressing student behavior. A lot of the clients that we see, if there had been someone in their school that just viewed their behavior in a different way, right? And didn't view it through a lens, through a punitive lens, then it could have transformed the trajectory of their lives. And so we really want someone in schools who can intervene as incidents occur and ensure that students are not being funneled into the criminal legal system. We're also pushing for the public school system to create more short and long-term therapeutic school options for young people that have very significant behavioral challenges. And finally, to expand access to intensive reading intervention. One data point that I didn't mention here were the pretty abysmally low reading scores for students that are in Passages Academy. And so this is literacy, something that I know there's a renewed attention statewide and citywide, but we really need targeted intensive reading intervention, especially for older students. So a lot of the literacy programs are focusing on younger grades and not really paying enough attention to middle and high school students. Second, while a student is in placement, we need to make sure that they are actually regularly able to attend school and that they receive the supports that they need to learn. So we need more school psychologists. There are only 2 school psychologists assigned to all Passages sites in New York City. And more related service providers, special education personnel. I know it's easy for me to say this, and I know in the last panel we talked about resources, but yes, we need more focused attention and resources on this population. And New York City has done this for other populations, which is why we're sort of trying to bring more attention to the issue of court-involved youth and making sure that they are receiving the attention that they deserve. And then finally, to really improve this transition process for students coming out of detention or placement, to afford students access to appropriate educational programs and support to really re-engage them in school upon return to the community. And so, our recommendations are very specific to New York City, and if you don't practice in New York City, it will probably be meaningless with like my specific recommendations. But the idea is that we just really need people to sit down and listen to our court-involved young people, understand, the path that led them there, understand where they want to go, and really, we have a lot of programs and resources in New York City. A lot of it is just connecting families to them. And so ensuring that there is a dedicated staff member, a transition specialist who is actually able to place a student in a program that can actually meet their needs. And so those are our key recommendations. Really, it's as I mentioned, it's the data and the report really focused and our attention, and hopefully will focus the city's attention on how we really need to improve these essential services that prevent, young people from being funneled into the juvenile or criminal legal systems in the first place. So, thank you.
Thank you so much. Next, we'll hear from Clarissa Jacobs, who will discuss equity in Indigenous education, including Article 83, and how it applies to Indigenous students in New York State.
New York State. First of all, I want to open with the just a small little, I did a little write-in before I needed to gather my thoughts on what I was going to deliver today. So I want to share the past of our ancestors, the present of our people, working for tomorrow's future. Our Indigenous tribal nations in New York State have learned the suffering of our ancestors through the history of boarding schools here in New York State, 7. And the last one that remains is that resides on the Seneca Nation of Indians out in Western New York. The history of Native American boarding schools is a complex and painful chapter in U.S. history. The establishment of these institutions aimed to assimilate Native American children into the Euro-American culture, often through harsh and abusive means. However, the resilience of Native American communities and their ongoing efforts to heal and revitalize their cultures demonstrate the enduring strength and resilience of Indigenous peoples. And with that, as a Mohawk woman, I fall under the Haudenosaunee Confederacy. Been in the position for 10 years. It's a very difficult position for myself. I worked in my community of Akwesasne all my life as a teacher, a mentor, coach, pretty much all around in my support of giving back to my community. And here I sit in Albany, in New York State Education. My past, the past individuals who sat in this position were from Akwesasne. I have to commend Elder Minerva White, who still picks up that phone at 90 years old and says, "What's going on in Albany, Clarissa?" I always share my experience with her, that it's very difficult, that I sit in two worlds. And under the Haudenosaunees, there are a two-row wampum belt. And that's meaning is the non-natives will travel one path in their canoe, and the natives will travel. And we will not ever interfere with each other's business and how our sovereignty will run as we work together side by side. So it's been a very difficult 10 years for me. I've seen our people, our schools. We oversee 13 school districts that are servicing our Indigenous students from Long Island to Western New York to the North Country. I've seen what has happened in our schools, and there's times when I have to pull back, and I have to always remember, you're there for New York State, Clarissa. So sometimes it becomes difficult for me. And when I came into the position, I was sort of scrambling through some boxes and getting a feel of the position. And I stumbled across this article. It was from 1975, and it was recommendations, 10 recommendations to New York State on Indigenous education. And I sort of dusted it off and started going through it. And I remember my job was to pull the tribal nations together and to bring everyone in one room, and they would hear what New York State had to deliver. And an individual stood up, Dr. Lori Quigley from the Seneca Nation, and she asked the, at that time, Commissioner Ilya, what are you going to do about these recommendations that were made in 1970? And to my knowledge, it seemed like she didn't know what they were about. And so it came back to us on a drive home with, at the time, my supervisor, who's now Chief Financial Officer of New York State Education, Christina Coughlin. I have to commend the great leadership that she provided for me. We had a long discussion coming home, and she says, well, let's update them and let's make revisions to these recommendations. And here we sit today with a pretty well, nice, neatly took those recommendations and we turned them into today, to meet today's, to accommodate our Indigenous folks. Commissioner Rosa, she had asked us to form an Indigenous Advisory Council, which we did, made up of every tribal nation in New York State with leadership. So there are 9 tribal nations, and some of them have 2 or 3 individuals sitting at the table with us. And they're our go-to people. And that's Dr. Rosa. Those are her go-to people. She has traveled to our nations. We have 3 schools that are ran by New York State Ed. The Onondaga Nation, the St. Regis Mohawk, and the Tuscarora Nation. And those schools have been there. I remember being a kid and I remember playing sports in the St. Regis Mohawk School. Today I see the St. Regis Mohawk School because I travel home a lot. I see the damage that was done when our nation took the flood, the dam out and created a flood. And yes, our school was flooded. So today, our legislatures, our representatives for the St. Regis Mohawk tribe are advocating for a new school. And we will push and push with New York State so that we can receive this new school. There's a lot of, when there's a lot of things happening, they always say the Mohawks are the ones that are the fierce ones who will get right in there and get the job done. So I'm counting on my leadership back home in our community. And then I stumbled across the education law of that the Commissioner of Education is authorized to contract with school districts to educate our children. But it doesn't stop there. It stops with making sure that our children are served in those schools and their needs are met. We have transportation contracts that we have to work with to make sure our children are transported, not just to the regular schools, to the BOCES programs and anywhere else they need. We also have supplemental service funds that also assist, and those are for academic success in our schools. So when I looked at all of, when I read the Article 83 and all the sections, there's under 40101, there are 19 sections. And when I was reading it, I said, Indian schools. Okay, this only applies to schools on the nation then. So we have a lot of work to do at New York State, and we do continuously make recommendations of change. We have a higher education program called the New York State Indian Aid. And we oversee that. That's part of our program. And those are funding for our college and university students. And what we do recently is we have been looking at our data on where our students are going. Those were our students who are in our K-12 schools at one time, and they're now in our SUNY, CUNY, and private schools here in New York State. So we advocate for these students in every manner. When we talk about, I've sat here today and I heard about students with disabilities. I see the data on my students with disabilities. When I look at teachers in our schools, we don't have enough schools, and I've been saying this for 10 years. We need to build a Native Teachers Education Bridging Program. We need to recruit these students right out of high school, get them in these programs. I mean, I was in a program, Native Teachers Education Program, Lakehead University, and in Ontario, Canada, pretty much every one of those Ontario colleges and universities have some sort of program that targets right back to Indigenous students and their programs and the careers that they can come back to. I sit here today in front of the law students. Thunder Bay, they worked very closely with the Anishinaabe Nation, and they took an old school and they turned it into an Aboriginal law school. So any Aboriginal student in Ontario can apply to that school, and it's all geared towards Aboriginal law in Canada. We look at Syracuse University as one of our highest populations of students. They have the Haudenosaunee Promise Scholarship. That's what drives the students to that school, is the Haudenosaunee Promise Scholarship. Now here, I listened about the immigration. Nyakwazasna sits on 2 provinces and 1 state. So you have Ontario, Quebec, and New York State. And what divides that is the St. Lawrence River. And Akwesasne has a big X mark on it for the smuggling trade. So I fear today, when I go home, I carry every identification I could put on this table, from a Canadian passport to a tribal nation card to my birth certificate, because I don't know when I'm going to be pulled over by Border Patrol. And I want to be prepared. I even carry my New York State pay stub with me for my proof. I fear for my brothers because they travel up and down 37 to go to New York City, and they're the Mohawk Iron Workers. My son just returned from Florida. He's an iron worker, worked at NASA, came home. I prayed. He drove all right straight through, got in yesterday morning at 4:30. And I said, make sure you have all your documents ready. Now I look at the children of Akwesasne and their future when we talk of immigration. So we worry because we have our school buses that are traveling along the Quebec border. And Akwesasne is, every entrance to get in through the Canadian is, there are Border Patrol sitting there. How I know that? I have a brother, older brother, who's a punter and trapper. As he's out, he pulls over with his 4-wheeler and he talks with them, and they said, yeah, we were told we have to sit at this border. So we try to, I was raised in a family of, my dad was an iron worker. My mom worked in a local um, Levi Strauss over in Canada. But they always told us, you know, if you're going to go and work out there and you're going to leave the community, you have to be prepared. You have to be prepared now. You're going to go sit in that part of that world. So you're going to be in both worlds because you're always going to come back to your community. And that's something I do. I travel home every 2 weeks to go and sit with my 91-year-old mom, who's still pretty darn sharp and pretty active, and she's a fluent Mohawk speaker. So with that, I just wanted to share a little bit about, you know, the struggles that we may face, as I've heard and listened to the talk of immigration. We talk about the mental health, and the addictions that happen. What happens in Albany happens on the reservation. And it, you know, when I hear of us, we losing a student in our community to a drug overdose, then I says, we have a lot of work to do. So I know there are talks that we have to sit down, and we may have to sit down with the immigration because of the border of the Akwesasne Mohawks. As we work together under the leadership of Commissioner Rosa and my supervisor assistant, David Frank, as we developed the Indigenous Advisory Council, we brought our attention back to the recommendations. And those recommendations were to focus on the expansion of more Indigenous involvement at New York State in the aspects of students with disabilities, bilingual language, culture. We do have an advisory council for that. We have the My Brother's Keeper. We provide an Indigenous college career fair every year. This year we'll be at the Onondaga Community College. We bring our high school students to attend, and our colleges and universities. And the other area that we're looking at is I'll be attending next week at Buffalo State to speak on higher education. And it is a form of Indigenous higher education individuals coming together and what they experience on the SUNY campuses. I'm always so proud of my students who have walked through our doors of funding. And when I look at my students who went on for law and I see them working back in their communities, when I enter the room and they're sitting there, and you know, it's always nice to see that they did return back home. You know, and that was the help of New York State through our New York State Indian Aid program. So we're continuously working to, you know, enhance our college and career and, you know, pathways. And we look at our BOCE programs, and not all our students are meant to be college university material, we say. I still remember when my brother graduated high school and told my mother, "Don't send me to college, I can't do it," he said. And I want to be an iron worker. I always commend those boys because, you know, there's always those stories I hear when they travel home. And it's such an honor when you have a brother that worked on the New World Trade Centers. And he always says, when my little granddaughter gets big, I'll take her there and I'll tell her, this is how we built the building, you know. So I always refer it back, and I always tell that story with our students. I remember walking into one of the Seneca Nation schools, and big burly kid sitting there. He had a pair of Red Wing boots on. I said, "You must come from an ironworker family." I said, "And you should be one because you look like the type." So I just says, maybe that will spark his interest into that career. We're always looking at those areas. We deal with many issues, you know, that New York State has to, you know, address with our tribal nations. I have to commend Governor Hochul. She was, I mean, I've never heard in my 10 years of a governor bringing together tribal nations. We held a tribal summit that brought all the nations and representations of New York State, the agencies, and our tribal leaders got to sit and speak with the governor. And then we were, you know, they went around from the New York State Health Department to the New York State Office of Mental Health, to New York State Education, to the lottery or the gaming They were, they were involved also, the Gaming Commission. And so we, my work is, there's not enough of me. There's not enough Indigenous people here in Albany. And sometimes it's lonely, but I always have to reflect back that why I'm here and who I'm working for. It's not for my leaders. It's not for, my peers or New York State Ed. It's for our students. It's for our Indigenous students here in New York State and the struggles that they deal with, and there's a lot of times when there's a certain incident that happens, it takes me where I want to go back home and be that teacher, that grade 1 teacher. Takes me back. I want to be that school counselor. So when I left, I think a big piece left, and I look at it today that if we're going to work towards our the diversity and equity and inclusion throughout New York State public schools that are serving our Indigenous students, it's long overdue. And our history, our people, the New York State Education Department, the Haudenosaunee, the Algonquin tribal nations, we've all implemented a government-to-government relationship, and that is to protect our treaties and inherent rights. And as we continue to implement Education Law 83, Sections 4101 to 4119, the work of New York State Ed Office of Indigenous Education continues to work with our 9 New York State nations, 13 school districts, 3 SAD nation schools, our leaders, our students, parents, and our communities if we want to have student success. But don't forget these laws that are implemented here in New York State. We have to remember when we mention sovereign, we have 4 nations that are very sovereign. And sometimes it's very difficult to get into those nations. So New York State is very, when there's a call to one of our nations, they'll say, Clarissa, make the connection happen, speak with the leadership, and I make it happen. I remember taking Christina Coughlin into the Onondaga Nation Longhouse because they had a walkout. They were not happy with the administration of the Lafayette Central School District, and they wanted their own principal. The St. Regis Mohawk have always had their own principal that is Native or a Mohawk that has served. And going back to Governor Hochul, she has provided the funding for our department to develop the public school resources. We are doing 18 briefs that are going to be provided through New York State Ed. And with that, we are now hearing from New York City public schools that they're also looking at where are the resources. So we're working very closely with the New York's, the museum in New York City, their Native American museum out there, so that we can collaborate together. There is no one textbook. There is no one textbook for our high school students, our schools, and our teachers. And we always ask ourselves, who's the best ones to teach about ourselves? It's us. It's the Indigenous people that should be teaching. There's not enough professors. There's not enough educators. So when I talk and I go back to that, building that teacher's education program, I think it's very vital. So I'm going to share that with my, in next week's, when I'm out at Buffalo State, about the importance of these bridging programs. And when we look at our data in our higher ed, and we don't see the numbers of Indigenous students going on to law schools, then who's going to be the ones who will protect those treaties, 20, 30 years from now? And I continuously, I sit on the state education leaders, and that is made up of, there's somebody in every state in the United States that holds a position like myself. And I hear of Arizona and the work that they're doing, but I have to commend that New York State is one of the first states that has pushed, for all schools, public schools in New York State, to dismantle the logos and the mascots. We worked hard on that. It was sat there, from the 80s, and it was untouched. And, Commissioner Mills was, pushing it, but didn't push hard enough. And then when Rosa, took her position, that was something that was, addressed, and she has the full support. And the work that she has in this article here, every one of our tribal nations provided a support letter for Dr. Rosa. And they are seeing the change that she has done in the collaboration with Governor Holko. So, Holko went out and she did the apology, to the Seneca Nation on the Thomas Indian Day School. So there is things happening here in Albany, that we're not forgotten. And when we talk of our Shinnecock and our Ongachug nations, I always say my brothers and sisters of Long Island, and I always reach out to them, and they always invite us out to their community. And, it's real interesting to hear about the history of the Shinnecock Nation and the Ongachug Nation. Ongachug Nation is led by he's a lawyer, Chief Harry Wallace, and he's a really advocate for his community. But he comes to the table with a lot of experience and, his on treaties. So having individuals such as Harry Wallace, sitting at the, at the advisory council is really important, that we have somebody that is following with New York state laws, and it implicates and has a, ripple effect from our treaties and our obligations. And, so with that, I'm really glad to be here. When I see law students, I always wonder, I wonder if they know anything about the treaties. I wonder if they know that someday they may be faced with, having to go up against a nation. We have the New York State, Akwesasne right now is finalizing with New York State on the land claims settlement that is happening. So what does it mean for me? It means that I'm going to have to accept those students who, now that land claims is now Indian land, but it right now presently isn't until the land claims is sealed. And all those students who live on the boundaries and borders now become my students. So the school districts are just waiting for that, because we can now include them into our tuition, dollars that we provide to the school districts. And that's it. Thank you.
Thank you. Next, we'll hear from Professor Gonzalez, who will speak about dress codes and economic sanctions that limit educational access and produce inequalities. Thank you, Professor Gonzalez.
Thank you. And thank you to Jessie and the Journal and all of the other panelists on this panel and the prior panels. So Jessie, I'm going to ask you a question though, because I feel like I'm standing between everyone and a reception. So I'd love to know, how much time would you realistically like me to talk? Because we all need to move our bodies, I'm sure, at a certain point.
I appreciate you asking, but I also know that you prepared a presentation for today, so I would like you to give the presentation that you plan on giving.
Okay.
Because we appreciate your time as well.
Well, no. I mean, to the extent, I think I'm going to introduce some ideas, introduce some stories. I really appreciate that from my co-panelists, that we're centralizing those that are most proximate to the harm, because as we do our work, that's not always necessarily us. I am thankfully no longer a middle school student, for example. That was not a time of life that I enjoyed that greatly. And so when I think about the work that many of us are doing around K through 12 education, in particular at this access point of equity and access in particular, it's because we're doing the work now as adults sitting in these different spaces. So as indicated, there's sort of two pivot points that I want us to conceptualize around. So in this broad idea of equity and access, and in particular, we've heard both in this panel and prior panels, this point about punishment. How might that punishment show up in different policies, and policies that maybe you have familiarity with, so things like dress and grooming codes, or maybe policies you don't have as much familiarity with, thinking about school-based educational fines and fees. And so I'll start with educational fines and fees, simply because it is a place where I really do hope, from both a local and a national standpoint, we continue to draw our attention to the ways in which school-based educational fines and fees are dispossessive, they're extractive, and they really do create a double burden for students and families. So what do I mean by educational school-based fines and fees? So there's two different forms, and I say that because one form people might be more familiar with, right, which is how I define as the school-based educational fines and fees. So things that happen in school, right? Activities, right? Behaviors that then have an economic sanction, a cost, a charge, a fee, a fine, but it's collected outside of the school. So truancy is a classic example of that. Right, so a young person is not coming to school with regularity for whatever, right, the intervening forces are that's creating that truancy, and then the school will refer out, or the young person gets ticketed, for example, by a school resource officer. But the actual cost and fee and charge, right, is being collected by the juvenile or the civil court context, and so it sits outside of the school. I'm going to leave those aside because there's actually been a fair amount of reform work and attention on those, including in the state of Illinois with legislation, right, that even limits and prohibits the use of punitive economic sanction ticketing for truancy. What I want each of you to think about today is those intra-school moments, those intra-school fees and fines and charges that are creating all kinds of harm across these different axes for students. So I'm going to give you two stories to start with. We've changed the names, obviously, of the young people or the parent caregiver in them, but I'm actually going to read it to you so that you have sort of the sensibility of their experience. So Chloe identifies as a Black female high school student, and she was living in an emergency shelter. She didn't have any access to supportive services, and she had lost her student identification card, right? So again, this is a high school student who's living in a place of transition, doesn't necessarily have all of the scaffolding that we would like to see for young people to have, is still attending school, but has lost her ID. She was denied access to attend school until she paid both a $5 replacement fee and an additional $1 a day fee for every day she was without it. Well, Chloe couldn't pay that, right? So this is occurring, and this is based on a case in the Commonwealth of Pennsylvania. So Chloe couldn't pay that, right? She was not in a financial position by which she could pay that $5 and now the compounding fees. So she couldn't come to school. She was now absent. She was accruing unexcused absences. And then the school referred her to the local district court for violation of Pennsylvania's compulsory school attendance law. So now she has both a intra-school set of fines and fees and costs, and she has an inter set of fines and fees and costs. And thankfully, right, Chloe was able to access legal services and they were able to intervene and she could attend school, but she was out for a period of time. So again, we've got a policy that is not just restricting her access to attend school, but now putting her in this place of increased economic precarity and punishing her for her status as being a young person that doesn't have stability and doesn't have the economic resources to pay what, for many of us sitting in this audience, or even myself sitting in this virtual space, a $5 replacement fee maybe doesn't feel like something that's inhibiting. This is not an isolated incident. Right? So it's not as if it's just simply in Pennsylvania this occurs. Across 49 states plus DC, when you look at, and we have coded empirically, the district policies for the two largest school districts by size, there is some form of fee, fine, or charge, or cost that is this intra one. So I'll give you another example. This is with a parent. So Destiny, and she identifies and wants to I would like to make sure that her voice is heard in this, as a proud single Black mother of 2 elementary school children. Her kids attend a Pennsylvania charter school, and she was experiencing delays and safety concerns on public transportation. Sort of like myself yesterday when I'm sitting on BART and I get a text that says that the Transbay tube is closed, and they have no further information, and I sit on the train for more than 45 minutes, and then it starts going again, and I get a new text telling me that it's been resolved, but I should expect more delays, and thus I missed my flight. So she came late to pick up her kids from school. She had called the school on the way to let them know that she was going to be delayed and was told, "See you soon, Mom." Right? It was the school's front desk. That person had a relationship with her. Let them know. She got to school, and school personnel then said, oh, she was going to be issued a late pickup fee. And it was $1 per minute for each of her children, because she was outside of what the school had defined as their 15-minute grace period for pickup. This fee was not negotiable. Payment was due immediately. And if she wasn't going to do so, regardless of whether she had an inability to pay or an ability to pay, she was not going to be able to take her kids home. Literally not going to be able to take her kids home. And then, right, it meant that she had to start to advocate for them, had to request additional staff arrive. And then what she was presented with was an agreement to pay. Then she could take her kids home. Again, right? Had to have legal intervention. Thankfully, there are wonderful organizations, including the Education Law Center of Pennsylvania, that are available, right, and handle these types of cases. But at the end of the day, right, these are not isolated, nor should these be the experiences of the type of economic sanctions or punishment that both young people and parents face. And so I share these as examples because this isn't a question that comes up, which is, well, schools are underfunded, right? Local districts, states, the pressures that we're seeing coming from the federal government is creating such a tight budgeting that there have to be charges or costs that get pushed onto families and students. For example, right, the laptop, right, or a rental charge that's associated with a digital technology, or a young person who's going on a field trip or doing something extracurricular. That's not what we look at, right? And this is not the type of modalities that are existing. So just taking Pennsylvania as an example, and I'll pivot here now in a minute to think nationally, in coding 729 local education agency policies, we were able to identify 3,846 different provisions that would fine, fee, charge, establish a cost. And it's not that they just had their own set of economic sanctions, right? Form of punishment that would be about debt creation for a young person or family, or about a resource extraction, but they also were dispossessive as to the young person and punitive. And that's that double bind that I want to now bring to people's attention. And I'll pivot now, also thinking about time, because I'm between you and your reception, right? Specifically in terms of high school graduation. So the work that I've done in the applied context, and in particular around educational fines and fees, first started in Pennsylvania, and we had the opportunity then to help the Pennsylvania legislature pass Act 1, which is a protective mechanism. Because some of you might be thinking, oh, well, it must be that even in the moment of having these types of policies that impact equity, that are inequitable and impact access, there must be waiver provisions. And I am sad to tell you that there are no categorical waiver provisions across any of these policies, whether we're looking in the context of Pennsylvania or we're looking nationally. So there's no state in which there's an identified policy, just taking the two largest school districts by size, right, of enrollment of students, plus DC, where there's a categorical protection or waiver from school-based educational fines and fees for all students. There's a patchwork of what students and families might have to ultimately work through. Sometimes that's tied to a student receiving free and reduced lunch. Sometimes that's not, right? It's not annual, and it doesn't just reestablish if in 1 year, right, a family has been able to show that and then have a waiver of these types of fines and fees as well. And it's not just simply like replacing an ID card or a late pickup charge. These are things like replacing a bathroom hall pass. So in an elementary school, for example, the replacement of a bathroom hall pass can be anywhere between $3 and $5 under a particular policy. This is things like library late charges. So I live in a city, San Francisco, where we are a fine-free library city. And our schools are also fine-free libraries, but many public schools across the country still institute a fine-based mechanism for when young people turn their books in late. And so again, those can accumulate. So what's the double bind then that I keep referring to? Well, this particular double bind is not just what Chloe experienced, which is you then get migrated into a juvenile context and you have now a larger and compounding truancy issue, both economically and punitively, but in particular as it relates to high school graduation. And that was the study that we just finished up. We actually released a research brief on today. So looking across all 50 states and DC, we were able to identify that there are 14 states plus DC in which if you don't pay, right, so you are otherwise eligible to graduate, you've met all the criteria, you have done all the hard work, right, that's necessary to think about high school graduation, but you have not paid your replacement ID fee or your locker fee or your late pickup fee or your overdue bind fee or your class dues or your records copying fees or your transcript admission fees or a textbook rental fee, all those potential fees, you will not receive your diploma. In those same 14 states and DC, you will not receive your transcript until you pay your outstanding fine and fee balance. In 6 additional states, it's not just that you can't receive your diploma or your transcript, you actually can't participate in the graduation ceremony. So now, right, we have this set of policies and systems that are sanctioning and punishing students, right, in these very particularized ways for behaviors that we should not be creating punishment and sanctions for. Losing your ID card is not something that should limit you from graduating from high school. Whether that's participation in the ceremony, which is an incredible space and place of emotional development for young people, a transition into adulthood, right? There is empirical evidence about the benefits of participating in that, but also the ability to just graduate and gain your diploma, which again, right, is associated with short and long-term individual and community benefits. Medical and health science research is very clear that education is a key social determinant. And in fact, right, high school graduation shows an increase in a person's lifespan anywhere from 6 to 9 years. And of course, right, for those that experience and have the ability to graduate from high school, you also see positive health outcomes, whether that's self-reported behavior, diminished social cycle stress, and the ability, right, to move forward within our society in terms of accessing other forms of jobs, higher education, and beyond. And so, of course, right, then the inverse, you have to imagine, and I would say this to you, and the research supports this, is true, that you get negative health patterning if you don't graduate from high school. And so why, right, why are we allowing for schools to limit, right, the access and opportunity that young people and families, right, experience, because this is certainly intergenerational, simply to maintain this type of racial capitalist regime? I think, right, that's the open question, and also the question that I put to all of you to think about, well, what are the possibilities of reform? Because again, even at a local level, we don't see the type of categorical protections, but then at a state level, we have so few states that have any of those protections. I remember Diana, and I'm a little more familiar with her name because I know her from other spaces where we've worked together. She made this caveat to you about public education, right, and states and a right to public education. What I will tell you is that in 28 states, there is a codification into the state constitution that public education is, and this is the important word, free. And so then we have to ask ourselves, right, if that's true across those 28 states, and when we think about within those 28, those 14 do lie, that are stopping education, that are creating barriers to high school graduation, and then across the entire schema of 49 plus DC, those 28 states also lie as well. Sort of what then would be the reform and legal advocacy possibilities? There's actually been very few legal challenges and litigation relative to this. California, is the state where I'm sitting in right now, is one of those, but California still does allow for different forms of fines and fees, so it's not categorical. Pennsylvania, right, is another I mentioned in terms of Act 1, but again, it's not categorical. It's not for all students. It's not for all fines and fees. But I will say, you know, the research that we conducted and we did in an applied context with community-based organizations was what was proffered to the state and helped them think about crafting Act 1. So if you're a law student in the audience, you could really be thinking about your legal skills in a both policy drafting standpoint and an interventionist standpoint across non-discrimination and ensuring that the civil rights and liberties and individual experiences of students are ultimately being met. So I'm going to take the palate cleansing breath, which is to say, let's talk about something different really quickly. Again, recognizing that I'm between you and your reception. So the other thing that Jessie had asked me to highlight was also another form of policies and punishment, I would argue, that create restrictions in terms of accessing your educational experience. And this might be the place and space that folks are a bit more familiar with, right? As I mentioned in the beginning, this is school dress and grooming code policies. There's an excellent report that the ACLU of Texas recently published that looked at just Texas K through 12 public schools and found that over half of the surveyed Texas districts mandated and enforced very rigid and outdated gender norms through their gender-based dress codes. This, right, might be familiar to folks in terms of thinking about hair length for boys, or right, the ability to wear one's hair naturally in locks, for example, or maintaining braids or twists or bantu knots, so that in all of those instances. So we're not now just talking about something that is about gendered inequities, but also racialized and gendered inequities. And then when you actually look a little bit further at these dress and grooming code policies, what you realize is there's actually a targeting of students for gender, for cultural identity, and also, in thinking about the last conversation, for the desire and willingness and ability to wear tribal regalia, in particular at graduation. So, you know, I'm going quickly, but I'm trying to set a little bit of a stage for us, of course. So if you're interested, I would look at the ACLU report. Another really important report that came out recently was actually across a number of organizations, including Legal Defense Fund, the National Urban League, the National Women's Center, Advancement Projects, and IDRA. And what they were looking to understand is the way in which the stereotyping, both gender, sex, race, were all then becoming part of a policing of expression in particular, and who and how was that limiting in terms of the ability to engage in your education and your school. But then how was that sort of coming forward? And so, you know, and that report contains a whole host of stories and examples, again, from those most proximate to the harm, young people in high schools and middle schools, ranging from, you know, 2 Black girls in a Massachusetts high school who were penalized with multiple hours of detention, threats of suspension, right? Removal from all of their extracurricular activities for wearing box braids, which the school dress code had prohibited, right? A few years ago, right, in 2021, in Texas, you had a Black middle school student who received more than 10 days of in-school suspensions for braiding his hair in a knot, and then was not allowed to rejoin his class until he changed his hairstyle. Following year in Mississippi, you had a Black female high school athlete who was disqualified because she wouldn't take the beads out of her box braided hair. So again, right, we're seeing this constant repetition of what it is to not allow children to exist within the safe and supportive environments. Or I think more accurately, right, is that we should query ourselves about why children should be punished for expressing who they are, right, representing themselves in whole being in those instances. So unlike in the context of educational school-based fines and fees, there's actually been a fair amount of movement in local, even though I set up some harms for you all, right, and gave you some examples of that, in local districts trying to pass what we identify, myself and others, as protective, culturally affirming policies, and also non-discriminatory policies. And so what might those elements include? That includes gender neutral terms. That includes naming what are protective hairstyles. And I don't just mean protective hairstyles as in hairstyles that are protected. I mean protective hairstyles such as braids, for example, that are aimed at actually protecting the texture of someone's hair. I know that and Wendy's Green work illuminates this, and she had a very fantastic conference last year on this. There is discussion about what is it to be natural versus wear braids or have a protective hairstyle, but at least, right, to identify different protected hairstyles, anywhere from locks to box braids, from bantu knots and beyond. To also protect religious wearing of religious garb or headdresses or other forms of religious expression. And now, more importantly, that exclusions don't exist for violations, right? So that suspension and expulsion linkage, that actual punitive removal of students, that is not there. And that any limitations that do exist relative to the expression of oneself, right, as we wear it in dress, as we wear it in our hair, for example, has to be related and directly related to health and safety. I think it's really important that students aren't forced to change, right? That there's rights-based language, that body shape and size are part of and prescribed into those core protective elements, that there are positive staff responses identified in the policy so staff know how to respond, that they're imbued with dignity and equity language, and that there's also resources available for children and families who experience, right, this type of discrimination or this type of harm. So that is a very short snapshot of both of those areas. I hope that was helpful. And as a backdrop, but also as a relationship to some of the other contexts in which our speakers were talking about, both in this panel, but then as a panel as a whole, right? Punishment still maintains, or carceral logic still maintains itself as a very dominant framework for students who are deemed to be the other, right? That otherness could be because of their gender expression, their otherness could be because of their ability and disability status, it could be because of their race, it could be because of their gender, or right where we know that that all sits at a place of intersection in ways in which identities show up. But when we have all of these different policies, they create, right, a compounding effect. So if a young person doesn't get to come back to school because they don't pay a fine, right, or fee, right, then they're limited from engaging in their educational opportunities. They may also be at risk for suspension or expulsion or in truancy, as we think about Chloe. Right? If a young person is wearing their hair naturally or it's longer than it should be, right, for purposes of a gendered expression, for being a boy, for example, then they're at risk for suspension and expulsion. So many of the things then that Diana and others were talking about, or even Amy earlier on in the last panel. So with that, I will be quiet. I don't know what's next because I'm unfortunately not there in person to see the visual cues and the physical cues, but I will turn it over to others.
Thank you so much, Professor Gonzalez, and I'd like to extend my sincere thanks and gratitude to our panel today for sharing their knowledge and for their valuable insights into this really important topic. Jessie, now we're going to turn to some Q&A. I understand. Do we have time for that?
I think we have run over time a little bit.
Okay.
But if most of our panelists will be at the reception, I encourage you to ask questions there. I know Professor Gonzalez, unfortunately, is not with us here today. But the remainder of our panelists, if they will be at the reception, I'm sure would be more than happy to answer your questions.
Thank you, Jessie. And thank you again to everyone. And thank you for putting on a fantastic symposia today. Thank you.
Thank you, Dean Tarana. So yes, if everybody would now please join us down in the East Foyer, we will be having our reception. Thank you very much.
Thank you.